that by order dated 11/9/2025, the matter was sent to the mediation, my lord. In fact, today is the date fixed before the mediation, my lord.
Okay.
That may I plead that matter may be deferred, my lord, if some positive way come out, my lord.
After the vacation?
My lord.
After vacation?
Yes, ma'am.
Heard, Mr. Hazarika, learned counsel for the appellant.
No, my lord. In fact, we have a joint prayer. Mr. Singh, he was coming, my lord. He called
Mr.
me.
Singh.
Yes, ma'am.
Mr. Hazarika and learned counsel for the appellant and Mr. Singh.
Yes, my lord.
He is
With
for respondent number?
assisting Mr. B.D. Kaur, my lord. All the respondents.
Okay. For the respondent, appraise this court that the matter was referred to the mediation and the same is listed before the mediator today. And on such count, he prays for listing the matter after vacation so that the mediator can file the outcome of the mediation to be undertaken today. Pair allowed shall list the matter immediately after reopening of the vacation.
My lord, in the first week of February, my lord.
First week of February. Okay.
My lord.
Lovely journal says. I beg to mention item number 15, my lord.
1-5.
Yes, Lord. I have already taken consent from the appellant side, Lord.
Mr.
M. Daswas.
M. Das, learned counsel for the respondent with consent from the other side, press for listing the matter after
Well, can it be fixed in the February, Lord?
February.
February. Then,
Okay.
yeah,
In the first week of February. Pair allowed. Yes.
Hey, please, Your Lordship. Lordship, I beg to mention item number 13. I have taken consent from the other side, Lordship. 13.
You are for appellant or respondent?
I'm for the petitioner, Lordship.
I'm for the respondent, my lord. I'm for the respondent, my lord. I only dead may be my lord.
Okay. As agreed by learned advocates of both the parties, recess shall list the matter after vacation.
Any date, my lord.
Oh, bless, Lordship.
In connection with the item number 7, I have highlighted additional activity, Lordship. It's not in the record, so Lordship, my submission, Lordship, and make call for this. Highlights.
May I please, Your Lordship? Lordship, I beg to mention for listing a transfer petition. It was filed on 5/12.
Take a date from him.
Lordship, I beg to mention for listing of an arrest matter.
Items for admission item number 1.
Lordship, this matter is led by the learned advocate in the Lordship. He's engaged in a parted matter, Lordship. I pleaded a matter with Adrian for the day, Lordship. Lordship, that matter will take some time, Lordship.
My lord, your lordship knows, my lord, I have concluded my part. And my lord, on 2 occasions, on earlier occasions also, adjournment has been taken on behalf of the advocate general. I'll not object, but then my lord, let them take a very short date and a fixed date so that my lord, on the next date also they do not ask for time. Parted matter, my lord.
Yes, suggested it.
Lordship. In the February. Yes.
Let it be the last week of January, my lord.
Last week of January, there is difficulty, Lordship. February. February.
Then convenient date ko ako. Next time no lo ba?
Next. Lordship, Lordship, the date maybe gets open. Lordship, Lordship, I'll ask my senior, let the court one, Lordship.
Okay. This court will not be sitting for next 2 weeks.
My
Yeah. So it should be listed in the first week of February. Suggest any date? The first week of February. As agreed by learned advocates of both the parties, recess shall list the matter in the first week of February.
Very well.
And confirm and Lordship.
Obliged.
Okay. Heard.
Deeply.
Item number 100.
May to your lordship, my lord, this matter was part heard by your lordship, my lord. Your lordship knows the facts, my lord, almost. Also, here what I want, the petitioner was selected in 1999. Then she was appointed also. Ultimately, my lord, her name appeared in the select list. There, one was fake select list, my lord, subsequent to my select list. And my name appeared in the page, serial number 35. And so I was appointed then. Then again, there was some complaints against me. There was some inquiry. I was again terminated. Again, I came to High Court twice earlier. Then ultimately, my lord, after inquiry and other things, third time we approached this court, my lord, your lordship kindly come to. And my lord, in 1999, your lordship kindly see, the NCT regulation in Assam came into effect from 2005 only. The NCT regulation requiring B.Ed or DLED institute was not there. So that diploma was not there then, only B.Ed or BT. So I was duly qualified. I am a graduate, my lady. So my qualification would be governed by the 1977 rules, my lord, who prescribed higher secondary for the LP school. So, my lord, I would be covered by that because the 2005 implementation of the NCT regulation would not come back to my lord, the effect. So ultimately, they terminated. Again, there was an inquiry. Again, the finding was in my favor. Ultimately, again, they terminated. Then I came to court earlier twice. Lastly, also I come to page 44. Well, also appointment order is, my lord, at page 15. There is 20th of November 1999, after the selection. My selection is that, my lord, that we noted, my lord, 27/7/1999. That's the lawsuit got, my lord. My appointment.
Page number 17.
Yes.
Yes. Got
Then I would adjust the, my lord, against date or retired teachers, my lord, at page 19. That is by order dated 28/3/2000, 2001. Page 19. My serial is there 13, my lord. No.
Yes.
Then, my lord, there was some adverse order against me, my lord. Then again, I opposed this High Court, my lord, at Annexure 3, page 20, my lord. You also can see that was order on 15/12/2011. So the honorable court, this honorable court asked the department to re-examine the matter through a committee constituted by the government about payment of salary. My payment, though I was appointed, my lord, against and adjusted against the retired teacher, but my salary was held up. So against that, I came to High Court. In the High Court, they took the plea, she is illegal appointee. So ultimately, this honorable court was pleased to order on 15/12/2011 to re-examine the matter by a committee constituted by government. The committee rejects my plea. You will also kindly find that Annexure 4, page 22. page 22. And the relevant portion is minor, page 23, order is the map. After careful perusal of the records and the decision of the expert committee, the government in education, elementary education department hereby rejects the claim of the petitioner for payment of arrear salary, arrear and monthly salary. Though I am working, I was adjusted against a post, my salary was not paid. And by this, it was rejected that they would not pay, but they would take my service. Then, my lord, I have also annexed the matter. Annexure 5, page 24 is relevant matter. You also can see it is a type copy, a relevant portion of type copy matter, and the original I have annexed full list. That this is the list matter which is genuine, held by the government also. 27. Here, matter we have shown that matter unreserved. My number is matter 1538, interview number, then Srimati Dole, and vacancy is Sandhya Rani De. So in her vacancy, I was appointed. Now we'll also come to the entire list, page 25 onwards. एक मिनट को भाई, My name appears at Malar, page number 26, serial number 35, Srimati Lovely Das. Address against Sandhya Rani De. 991 Ko Navin Vidyapith. You will also got my lord?
Got it.
Yes. And this list was, my lord, approved by the chairman. You will also can see page 27. Verified Sunsudo and with the original records and yes. And this was also signed by Superintendent, Director of Elementary Education, Assam, Deputy Principal Schools, Karimganj. Now, my lord, the illegal list I am showing to your lordships, was held to be illegal by the government. Annexure 6, page 28. This list was, my lord, fake list dated 13/11/1999.
My name is. My name is not.
My name is not there. I have annexed the entire list, my lord. My name is not there. Your lordship, this is the entire list I have annexed. Then, my lord, will also kindly come to list of annexure 7, list of all appointed candidates in the district. Page 31. And my name appears, my lord, page 32.
Mr. Sharma,
Yes.
you say one list is produced by you. According to you, that list is genuine.
Yes.
And the government has produced another list, and they are claiming that that list is genuine.
This.
Now the
No,
question
I'm
is a
coming to, I'm coming to.
disputed question of fact. Can this court
No,
embark
I'm not,
into-
no, I'm, just I'm briefing this fact. Ultimately, your lordship will see. Just I will complete within 5 minutes, my lord.
Hmm.
Then, my lord, all the teachers, those who are appointed in the district, this, my lord, annexus 7, this is I have produced.
Hmm.
My name appears, my lord, in page number 32, my lord.
Hmm.
From below, serial number 2, 4. Lovely Das, my page was still held up.
Hmm.
Yes, you got, lordship got, my lord.
Hmm.
This is the list of appointees of entire district of Karimganj, now ceremony.
But who prepared this list?
My lord,
Who had prepared this list?
this is, my lord, signed by Deputy Principal Schools, then another signature there. The 4 signatures are there.
Hmm.
Probably in the Deputy Inspector Schools.
Hmm.
Deputy Inspector, then another countersigned by another person. Then there is short signature, 2 signatures. Now I will also going to come to again annexure 11. There is 11. After inquiry and based on the SC order on retail bill number 111 2007, government directs for our appointment. You will also going to receive page 39.
Hmm.
Page 39, annexure 11, my lord.
Hmm.
Ultimately, findings of the government is there in the second paragraph.
Hmm.
Then you will also kindly see the ultimate order passed page 40, decision,
Hmm.
page 40, has also got, my lord. In view of the above, the Director of Elementary Education is directed to appoint the persons in the select list prepared in the meeting of the Sub-Regional Level Advisory Board on 27/10/1999, my lord.
Hmm.
First list. And authenticated by the chairman. This is the government, my lord, in the education department, elementary education department, signed by secretary. Now I will also kindly come. Now they have appointed me as tutor. Against that, again I came to High Court. Annexure 13, page 43. In the order dated, my lord, that 18/8/2009,
Hmm.
page 39, my name was not there. So, my lord, I came to High Court. Annexure 13, page 43.
Hmm.
That order is important. Page 44, my lord, relevant page. May I take a lordship through, my lord? Heard A. Rashid, London Council for the Petitioner, also heard Madam N.J. Khataniar, London Standing Council Education and Elementary Department, Miss Deuri, Mr. B. Deuri, London Council Government Advocate. This is the second round of litigation at the instance of the petitioner seeking for removing the clouds about the regular appointment of the petitioner so that the petitioner can continue in her service with regular salary. The petitioner claims that she was selected, approved by the district level selection board for elementary education Karimganj and was appointed on 20th of November 1999 at number 499 Duhalia AP School. Subsequently, her appointment was adjusted against the vacant post of number so and so at Nilamani LP School. where she has been working, serving till now. Yes, there was some issues regarding the genuineness of the appointment of the prisoner. The prisoner approached this court by WBC number so and so, which was disposed of by this court on 15/12/2011 by directing it to be placed before the committee, which was constituted for the purpose. In terms of the direction of this court, Sudhendu Mohan Talgudar versus so and so. Pursuant to a direction of this court, the case of the prisoner was placed before the committee, and on the basis of the recommendation of the committee, the impugned order was passed on so and so, rejecting the claim of the prisoner for payment of salary and monthly salary, area and monthly salary, on the ground that the appointment of the petitioner was illegal. It is this order that is which has been challenged in this petition. Perusal of the aforesaid impugned order would clearly indicate that there was finding to the effect that there were two select list of the for appointment of stability teachers. One select list was dated 27/10/1999, mentioning 112 numbers of candidates, and there was another select list dated 13/11/1999, mentioning 72 numbers of candidates. There was also finding that the said select list dated 27/10/1999, having 112 of the candidates, can be treated as a valid document, and the other list dated so and so 13/11 cannot be treated as valid document. There is also a further finding as reflected in the impugned order dated 18/7/2013 that the name of the prisoner does not figure in the select list dated 27/10/1999. On the other hand, her name finds place in the second select list dated 13/11/1999. Actually, it was held that since the name of the prisoner was not included in the very list, select list, but included in the very list, the appointment was illegal and as such not entitled to arrear and monthly salaries. On the other hand, London Council petitioner has drawn attention of this court to Annexure 7, which is stated to be select list dated 27/10/1999, which was also referred to by the committee and reflected in the impugned order dated 18/7/2013. In the said select list produced by the prisoner, copy of which is annexed as Annexure 7, the name of the prisoner finds place in serial number 35 under interview number so and so, and the prisoner has been recommended against the vacancy which was earlier held by Sandhya Varani De, Nabil Bidapit. The said select list is signed by the Deputy Principal of Schools, Karimganj, and is said to be verified by the Superintendent Director of Elementary Education, Assam. The prisoner has also drawn attention to the court to the select list dated 13/11/1999, which has been held to be invalid by the committee, as reflected in the impugned order dated so and so, in which the name of the prisoner does not figure. Thus, from the above, what has been said, what has been seen is that while authorities have given the finding as reflected in the impugned order dated 18/7/2013, that the prisoner's name does not figure in the very list dated so and so, the prisoner has been able to show a list state to be select list, valid select list dated 27/10/1999, supported by ABDB, that her name indeed appeared at serial number 35 of the list. Thus, from the above, what is clearly evident is that the finding of the committee that the select list dated so and so does not include the name of the petitioner, and the production of the list by the petitioner in this petition, in which the name of the petitioner is included in the release data so and so, is within the realm of the ascertainment of facts. As such, this court is, for obvious reasons, cannot undertake the exercise. What your lordship is saying, my lord, that was material. Undertake the exercise to ascertain the correctness of either of the claims. However, since the petitioner has been able to show certain documents supported by affidavit, this court would direct the respondents authorities to re-examine the claim of the petitioner in the light of the select list produced by the petitioner in the petition and make another verification as to whether the name of the petitioner finds place in the list that is so and so. It goes without saying that since there is already finding of the authorities that the select list so and so is valid, and if the name of the petitioner is found to be included in the said list, as claimed by the petitioner on the strength of the document relied upon in this petition by or any other document as may be available, the petitioner would be entitled to be declared as validly appointed teacher, and she shall be entitled to all the consequential benefits, including area and current salary, for which the respondent authorities will undertake a fresh verification process as directed by above and inform the result of the same to the petitioner by issuing a speaking order in this regard, which exercise shall be taken within a period of 2 months from the date of the receipt of the survey commission. So thereafter, my lord, what happened? You will also kindly come to page Annexure 14. This order was passed by the Director of Elementary Education on 21st of September 2020. Because of subject cited above, I would like to inform the Honorable High Court it has passed the order so and so, dated so and so. However, since the High Court order is quoted here, my lord, then ultimately you will also going to come to the page 49, last paragraph. Therefore, the government is requested to let this office know whether the petitioner case was placed before the expert committee and if yes, kindly provide the copy of the minutes of the report of the expert committee for taking necessary necessary action for compliance of the Honorable High Court order dated so and so. Then annexure 14, page 51. Something is retyped, madam. It was not clear, so type copy is given. Then, my lord, annexure 15, page 52. That is improved here. He passed an order for a tutor with salary of 10,000 fixed salary. So here the contents is, madam. Director of Elementary Education passes the order. My appointment was given as tutor, not as regular teacher, with full salary. He has fixed salary of 10,000. So ultimately, the government and the directorate accepted that I am a genuinely selected candidate and genuinely appointed earlier in 1999. Now the crux to be decided here is whether here the palpably and ground is that I did not have B.Ed, B.T. or D.Ed, because I am simply a graduate. So, they have also issued the order, you have also kindly seen last annexure, page 54, annexure 15 itself. Here I have been appointed, merely appointed a tutor, Lovely Das.
So now you are working as a tutor.
Tutor.
with fixed salary.
Fixed salary.
Now,
Lord, the
your
court-
claim is,
So the question of my validity, invalidity, legal is gone. Now government accepted, I am legal.
Mm.
Now question is whether the B.Ed, B.Ted, DLED would be applicable in my case since I was appointed in 1999.
Regular slider, that's what I.
So my qualification would be covered by the 1977 rules, my lord. I am showing that, which came to amended it Puran Kitabul. Amended, my lord, in 2005, whereby having B.Ed, B.T. is compulsory now, mandatory after the coming into force of the NCLT regulation. Your lordship might not have that book, my lord, the whole book. But I think in the other book also it is available. 77 rules, 1977 rules. Assam Elementary Education Provision Rules, 1977. এটি নতুন কিতাবও পাওয়া যাবে। amendment নাই। पेज में पुराना किताब तो 16 खोलने वाला असेल यात just a minute मालिक, I may be excused.
Serial number. 14 serial.
14 my lord, page 293. Is this the book, my lord? Your lordship
got
holding?
it, got it.
293.
Which is the provision?
I am coming, my lord. This is the rule, my lord. It was amended in 1997 also. Then also kindly come to education. Qualification, my lord, page 296.
Mm.
Yes, then comes the qualification. The minimum qualification of a person, this was substitute rules, to be eligible for appointment as a teacher in elementary school shall be as per the notification issued by the Gazette by the state government from time to time, in conformity with the NCT norms. These qualifications shall be applicable to all category of elementary schools. In case of any relaxation required in respect of any qualification is prescribed by the NCT from time to time, the state government shall take up the matter with the government of India for such relaxation. Now this was something my lord also kindly come. Earlier, my lord, you also kindly come to below. Roman serial number 3, my lord.
Mm.
Your lordship will kindly come to note. Clause 3 has been substituted by notification dated so and so 2005. It is so and so. It is so and so dated 10th of the, November 2005. Am I clear, my lord?
Mm.
Note below. Yes. So this qualification, added qualification came into effect, my lord, from 2005. The NCT regulation norms had to be fulfilled. 2005. And published in the Assam Gazette on 10/11/2005. Now, further below. Qualification. Matriculation shall be minimum qualification for the post of teacher in element. This was the existing qualification earlier, simply matriculation. Even higher secondary or graduation was not required. Only after 2005, my lord, the graduation for science teachers in elementary education also, for others higher secondary qualification, for arts and commerce, commerce is not there, for arts came into being. So my contention here, the legal point I am urging in this case, because to get the full salary and to be a very regularly, normally appointed teacher as on date, should be my lord, I must have the due qualification as prescribed under law. So at the present, after 2005 onwards, and also the earlier rule, provincial rules, 2011 Act 2011 was struck down by this court by division bench on 23/9/2016 by division bench. And then thereafter my new act came in 2017. So in that also BA, DLED, BT is compulsory. But my case is, my lord, since I was appointed prior to 2005, so I duly held my qualification being a graduate. Here matriculation is required. Then it was matriculation only in 1977 rules until it was amended in 2005, requiring the qualification as prescribed by NCT regulation. So, my lord, I had the qualification, and the NCLT regulation and this rule as amended in 2005 could not have retroactive applicability. So I am duly qualified. So I am entitled to full salary. There is no contestation, my lord. Am I clear, my lord?
No, that's all right, but you see the section 24 of the new act?
No, section that will not cover my case.
Hmm.
Section 30, I know.
Hmm.
Yes, but that will not cover my case. I am to be entitled, I am entitled since 1999.
Hmm.
That new act, 2011 act would not come. Even the 2005 amendment of the rules would not come.
Hmm. Hmm.
So since I was qualified then, if I had not, I hadn't started paying salary then I would be continuing with the full salary. There is no scheme of tutor
Hmm.
until 2011. The act after 2005 amendment matter, then only 2011 act, these qualifications came into being. If I had been paid then, without any hassle, who is ultimately they had to accept, yes, it is legally appointed teacher. Then I will continue with that, with area and other things, with all allowances and DA and other things. Luck was there, my lord. They really dealt with the matter. And ultimately, one inquiry after inquiry, I had to come 3 times to court. Then only they surrender, yes, is a legal appointment. If 27/10/1999, this is valid, my name figures there.
But
Every
Mr.
dispute that-
Soma, you see now this 77 rule is no longer there.
No, 77 rules, one and 77 act still exist. That is the tragedy in Assam education. Here you pass the one act in 2011 and also 2017, 2011 having been struck down on 16/9/2016. Then you pass another act. But there is, you'll also can see, there is no repealment of 1977 act or 1974 act. First act that came into being, my lord, was in 19 after the earlier schools were held by board, education board. Then government decided in 1973, 72-73, after there was election in 72, Sarath Chandra Sinha was the chief minister, my lord. They decided
So
to have
this 1977 rule is still there.
yes, rule and act. You'll also only see. You'll also only come. First, you'll also only come to 2017 act.
Hmm.
In Meghalaya, my lord, one education code covers all the education systems in Meghalaya. Here, about there are dozens and dozens rules and acts. Still, that's why maximum cases are away from education department now also. Hello, Sungani County 2017 Act. Your Lordship, that is a page 99.
Hmm.
Now, your Lordship will go to direct the repealment for provision of for repealment. There is no provision for repealment. Has your Lordship got matter? Interpretation, removal difficulties, website, power sanction, obligation, procedure so. This is complete. You are 74%. Repeal and saving, you also kindly find page 24, annexure 20, sorry, section 24 is page 126.
Mhm.
The Assam Venture Education Issues Act 2011, so and so, as amended by so and so, project. And the Assam Venture Educational Institutions Performance Act 2013, which have been struck down by the Honorable High Court on 23/9/2016. I had already told the date to your Lord's Matter in WBC number so and so. That was a case done by me and Nilay Datta, where we challenged it and it was got struck down. I was the junior with Nilay Datta. And all rules, orders, notification issued thereunder shall stand repealed. However, all the teachers whose service were professionalized prior to 23/9/2016 shall continue in their cases shall be reviewed as per the eligibility norms and so. And also a lawsuit, kindly, I may take a lawsuit to 2011 Act also.
Hmm.
There also, with 77 Act and rules, 11 Act so 2011. 2011. Yes. Assam Venture
Financial education service.
2011 Act is not published in this book. After its repealment. There also in 2011 Act also, madam.
Hmm.
Page
Page number?
No, madam, 2011, I don't think it is published in this book.
Six,
because-
647 page number.
Madam, oblige, madam. 647. Yes, yes. I am grateful to your lords, 647. Now let's kindly come to the last section therein. Here I don't find matter there is any repealment. None. Last section is matter power to make rules. So matter the 77 Act so rules along with the Municipal Act of 1974. 1974 was the matter act by which first act of Assam Assembly matter, Assam government, by which the government decided after study about for 2 years, after the new government of Mr. Sinha came into power, that school should be no more held by the school boards. They should be provincialized, giving full benefit as government servant to the teachers. So in 74 the act was passed, Assam Elementary Education Provisions Act 1974.
Hmm.
Then in 77 another act was passed, Assam Secondary Education Provincial Act 1977. And rules was passed in 1977, which rule I have referred. (293).
So, these act and rules are still in force.
Yes, it's still in force.
And your contention is that your case has to be considered under the 1977 rule and
in
Act of
1974, 1974 Act, Man Act is 74. You will kindly again come to 293.
Hmm.
I'm traveling, your lordship. I'm sorry, my lord. Page 293, my lord. The provision under which this rule 1970 rules was passed, elementary education rules. Here's the lordship got my lord.
Yes.
Yes. May I read? In exercise of the powers conferred by the proviso to Article 309, the 309 constitutional rules
Hmm.
of the Constitution of India, the Government of Assam is hereby pleased to make the following rules regulating the recruitment and condition of service of the teachers of the elementary schools which have been provincialized under the Assam Elementary Education Provincialization Act 1974. So there was the first act for provincialization in Assam. 1974, elementary education was provincialized. In 1977, secondary schools were provincialized. Secondary schools included for ME level to class 12.
Hmm. Hmm.
So these rules existing still live and active. So government cannot say that no, this rules are gone. So 2017. How can 2017 in any case would come, my lord? I am appointed in 1999, about 18 years back. Can the 2017 rules work back to 18 years?
Hmm.
So this is the crux of the matter, my lord. That's why I had to take a lawsuit through entire pages of the petition.
Hmm.
Government has accepted, yes, I am now validly appointed, selected. And you appoint me, presumably, as not having the qualification B.Ed, B.Tech, DNL, as tutor. Now, one more thing, your lordship can see, to be very clear. Your lordship will again come to 2017 Act.
Hmm.
Well, sure for that, right? এটা দেখাশোনা না করবে।
17.
Page 99 again, madam.
Hmm. Yes.
Now, you also kindly come. My lord, section perhaps 6, just a minute, my lord. Section 3 is, my lord, eligibility criteria for selection of educational institutions, performance license, this is not required. Then, my lord, will go. Section 6, education, professional qualification of teachers. Has a lot of water, page 115.
Yes.
Under 15, my lord,
Hmm.
section 6. The service of the teachers in a venture education institution from the primary level to up to the degree level shall be considered for professionalization in the post of teachers or relevant teaching faculty in appropriate nomenclatures as the case may be, subject to fulfillment of the eligibility criteria relating to educational and professional qualification as laid down under the following acts. Right of Education Act, the National Council for Teachers Education Act 1993, then Assam Secondary Education, MC grants, and so on. Now, my lord, again, a lot to go to the terms and conditions of service. What will it do? It has no. Yes. Section, my lord, 8, 6, subsection 6. The teachers and tutors provisionalized under this act shall hold personal posts to be created for provisionalization of their services. These posts shall be outside the cadre which shall stand abolished for cessation of service of the concerned teachers or tutor. So regarding tutor, my lord, those do not have qualification of B.Ed. BT, they shall be declared to be tutor. This civil law will find. Tutor is defined, my lord, in section of the definition, my lord.
Okay, we are not concerned with that provision now.
Yes. No, just a
If
minute. Just my lord, I'm pointing out.
77 rule is applicable in
Yes.
your case,
Yes,
then why should we confine ourselves
yes,
with
that's
the
true, my lord.
Act of 2017?
Obliged, my lord.
Yes, Mr. Sharma.
Lordship to the order of accommodation, Lordship, page 54 of the petition. This is an order of accommodation. This accommodation order was issued in terms of the candidate decision Lordship, your Lordship is aware. That during the period from 1991 to 2000.
Page number?
Page number 54. Annex 15 of it. This accommodation order has been accepted by the petitioner.
Yes, yes.
And he has been accommodated as tutor, he accepted it, joined it. And he drawing salary. Whatever lordship is, as a tutor, he is eligible for. Now may I take a lordship to the prayer portion of the petition? Page number 10 of the petition. It is therefore prayed that the lordship may be free to this passing the record which you will calling upon the records to so far as to why. In the name of, mandamus of such order should not be issued, directing them to regularize the service of the petitioner as the school teacher and to direct them to release area monthly current salary allowances to the petitioner who is serving as assistant teacher under the so. So in this accommodation order has not been challenged. It has been duly accepted and joined and drawing salary. This is not under challenge, this accommodation order. Now lordship, may I take a lordship to page number 22, the first order, speaking order. Page number 22, annex 4 of the petition. Findings part, lordship. It appears from the records that the petitioners along.
Page number, Mr. Sharma, page number.
Numbers of candidates,
Mr. Sharma, page number.
page number 22, lords.
Annex 4, my lord.
Annex 4. Of the petition.
Yes.
Lordship, to this findings part, lords. It appears from the records that the petitioner along with other 83 numbers of candidates were appointed by the then Deputy Inspector of the Schools, Karimganj, as the supplementary teachers on fixed pay from the two controversial select lists, lordship. This is important, lordship. Two controversial select lists. One select list dated 27/10/1999 mentions 112 numbers of candidates. And another select list dated 13/11/1999 mentions 72 numbers of candidates. The name of the petitioner figures in the second list. That is the list of 72 candidates.
No,
Name
but
of the
no,
petitioner figures in the second list. That is
Mr. Sharma,
Lordship.
you say Thereafter, her service, no, she has been appointed as a tutor.
Lordship, in terms of the cabinet.
Yes, yes,
Sir, cabinet memorandum, she was appointed as a tutor.
tutor. Now her claim is for arrear salary and for being appointed as teacher,
Lordship, regularly.
not as tutor.
Not as tutor, no. Her main prayer is area salary from the date of appointment.
Now, Mr. Soma, you tell me
Lordship.
whether at any point of time you have raised any question that she has not been discharging her duties since the time of her joining?
That lordship, I will take your lordship through. my-
No, you first answer my question.
Lordship. No. She was admittedly appointed by the DI of the school
Mm.
without following due process of law.
But she has been discharging her duty from the very date of her
Yes.
appointment.
But subsequently, she was not paid any salary.
Mm.
Thereafter,
Maybe
during the period.
there is a decision of
No.
Supreme Court that you cannot, no, of this court, division bench,
Lordship,
that you cannot obtain her service without paying her salary.
lordship, here the question is lordship, the very appointment of the petitioner was illegal.
Mm.
Without following.
No,
due
no,
process of law.
no, Mr. Soma, perhaps you were not aware of that decision.
Lordship,
Division bench decision is there, irrespective of regular or irregular appointment.
lordship,
If the state respondent obtain her service
lordship,
without paying any salary, then you are bound to pay her salary on the principle of quantum merit.
lordship, in that case, lordship, may I take your lordship through the cabinet memorandum once.
Mm.
May I take your lordship through the cabinet memorandum once.
Mm.
What is the factual aspect of the?
No, we will not go to the cabinet memorandum, not required. You first answer my question that whether you have disputing that she has not been discharging her duties since the date of her joining.
We are disputing that. We are disputing,
Where?
we are disputing that.
You show the averment in your pleading.
Lordship, may I take your lordship through the affidavit filed? We have filed two affidavits.
Mm.
We have filed, because lordship, the very selection list which the petitioners claim to have been appointed.
Then
by-
how you have appointed her in the year 2021 as tutor? On
Lordship,
what basis?
That I will clarify. That I will clarify by going through the cabinet memorandum once. Lordship, may I take your lordship 2 minutes time, lordship? I
Mm.
will just relevant portion of the cabinet memorandum I will go through
Mm.
for your lordship.
Mm.
Cabinet memorandum of that cabinet approval was given on
Yes.
2020.
Mm.
What that cabinet memorandum said, a large number of teachers who were appointed irregularly and illegally in lower primary and upper primary schools all over the state
Mm.
during the period from 1981 to 1989 and 1991 to 2001. The more particularly in Dhemaji, Lakhimpur, Sibsagar, Kachar, Kalimgan, Hailakandi, Bongaigaon, Nalbari, Dibrugarh, Jorhat, Golaghat, Nagaon, Morigaon districts by some field level officers and school managing committee without following the provisions laid down in the Assam Elementary Education Provisionalization of Services Act 1974 as well as the rules of 1977. In terms of the Honorable Court's order dated 2/3/2010 passed in WPC number 1048/2004, the Education Department placed the matter of regularization of irregularly teachers before the cabinet meeting on 26/2/2011 with a view to examine the nature of appointment, status of post, working status of salaries, academic qualification, etc. The Director of Elementary Education Assam invited application from these irregularly and illegally appointed teachers during 1991 to 2001 throughout the state by advertisement dated 1/2012 and 4/2012. There were two advertisements were issued for these teachers in local newspapers. In response to the aforesaid advertisement, applications were received from such category of teachers. After preliminary examination, the applications were received at the director level. The Elementary Education Department constituted 5 screening committee headed by the divisional commissioners concerned and principal secretaries of the 6 scheduled areas to examine these applications. preliminary committee report. After the details and through scrutiny of the records, also after affording personal hearing to the applications, the screening committee submitted reports to the government after examination of the government level. The following facts have been noted. A large number of candidates were appointed on 6/12/1999 at Simsagar, Alwari and Lakhimpur district. That is the very day on which the ban of the appointment was issued by the government. Number two, a substantial amount of candidates of Nagaon and Molgaon districts were appointed by the school managing committee of the schools, but according to the procedures laid down in the Assam Elementary Education Professional Rules 1977, school managing committees had no power to appoint teachers in the public schools. Number C, all the candidates were appointed against non-existent posts, that is in excess of the existing posts. Number D, no records regarding the appointment proceeding books, select list, etc. are available in the districts concerned. Most of the illegal and irregular teachers were found irregular in attendance in their respective schools. Most of the teachers did not receive salary right from their date of joining, and some received salaries up to certain period. Only all salaries were discontinued since 2007. Only the teachers of Simsagar district received salary up to 2012 by grading supernumerary post. After scrutiny of the report, screening committees, the final outcome is as follows. Category 1, the recommended and working team that is 136 teachers. They were recommended but discontinued with the jobs 250 persons. Number 3, category 3 is not recommended but working. Not recommended but working. With the petitioner comes under 8470 person. Number 4, category 1, not recommended and discontinued with the job. 2,900 candidates were not recommended and then discontinued also. Based on the report of the screening committee, 136 teachers of category 1 have already been regularized in service. It is pertinent to mention here that the addition of 8,470 teachers under category 3 in respect of 700 and in respect of 752 teachers of who were already terminated from services in 1992, along with 40 other teachers of similar nature. Hearing was conducted in the office of the Director of Elementary Education in the month of June 2016. All the 752 teachers in districts were found to be appointed illegally, irregularly in the year 1989 against the non-existent post. But they were all terminated in 1992 by releasing their stipend after 29 months. All other teachers received stipend after 29 months, but they continued to attend schools illegally. During the screening process conducted by the DE Assam, it was found that a large number of these 752 terminated teachers, along with other 14 teachers of similar nature, were absent from their duties in their respective schools for the period of 6 to 7 years, but subsequently attended the schools illegally. Therefore, their position is also similarly placed as in the case of teachers of category 3. Having regard to the above, it is clear that the appointment of the 8,470 teachers of category 3 as well as 752 of and 14 similar teachers of Dhemaji districts for under the following distinction. Appointed during the ban period. These teachers were appointed during the ban period, appointed by the managing committee, appointed against non-existent posts, and wrote no record of valid appointment. That being the position, Director of Elementary Education Assam was directed to issue a cumulative focus notice to all 8,470 candidates and also 766 and 752 terminated teachers of Dhemaji and Lakhimpur district, including hearing so the reasons as to why their appointments are not deemed to be illegal or irregular, and as why they should not be removed from service for being so appointed in violation of the existing rules. The screening process has been completed on at this stage. Cabinet memorandum. In fact, this is a cabinet memorandum. All other cases we have already annexed this, but in this particular affidavit, this cabinet memorandum is started. In fact, the law Lordship is aware of that cabinet memorandum.
Hmm.
Now, Lordship, for this 8,470 teachers, the screening process had been completed at this stage. However, in the meantime, the discussion was held between the Honorable Minister of Education and Teachers Association of Irregular Illegal Teachers. As per decision of the meeting and as per the suggestion of the then Honorable Minister of Education Department, had proposed to take a decision to solve a problem of these irregularly appointed teachers subject to approval of cabinet on the following policies. What was the policy? Those who have been drawing salary at some point of time and after received appointment and have passed the junior basic training prior to 3rd September 2001 or whose educational qualification as per the date of fully according to the NCT norms. The teachers who have fulfilled the following criteria: drawing of salary at some point of time and qualified junior basic training. They would be and GPF account. They would be accorded as teacher. Thereafter, the committee has prepared list 1, list 2. There were 2 lists. List 1 was teachers who have received salaries of some point of time, which has ultimately been fixed up to March 2007, and having joined junior basic training, not DLA. The number of teachers included in the list was 1,574 teachers. These 1,574 teachers were ultimately accommodated as teacher because they received salary up to some point of time as well as they had a junior basic training. Now, list 2, the teachers who received salary at some point of time, but having junior basic, not having junior basic training or DLA. Now, this is the case where the present petitioner is categorized because he has been receiving salary up to some point of time, but subsequently she did not have the junior basic training. As a result, she was accommodated by the accommodation order, which is annexed by the petitioner at the annex number 50.
No, you say she was appointed in the year 1999.
1999.
Right.
She was, now also I will just.
What was the qualification for being appointed as teacher at that point of time?
That is the 1977 rule.
Yes.
Lordship, that is there.
Then
1977. Now I will take you through the very select list against which the petitioner claimed to have been appointed.
Hmm.
May I take a lordship because of the last.
No, Mr. Sharma, you say there is an observation of this court
Lordship,
in the order dated 12/3/2020
lordship,
that the petitioner has produced certain documents
lordship,
in her favor, in support of her claim,
lordship,
and thereafter direction was issued to the director to re-examine the matter,
lordship,
and the director, after examination of the same, has appointed her as the tutor.
that she was
Then-
appointed as tutor subsequently, lordship.
Hmm.
But according to that select list. to which the
No, we will not go to the select list now.
Original select list of the last.
No, no, we will not go to the original select list because there is already one finding of this court.
But lordship, the way.
No, no.
The petitioner has been accommodated.
Mr. Sharma,
For a moment.
sorry, Mr. No. No.
Yes, my lord. Dr. Time is here a moment.
No. You say whether the observation made by this court is challenged before any division bench or Supreme Court.
That has not, subsequent year to the petitioner has been accommodated. Subsequent year to the petitioner has been accommodated.
Yes,
In the-
no, the finding of this court
Lordship,
in the WPC number 5091 of 2013,
Yes.
that has not been challenged before any division bench or the Supreme Court.
509 from 2013.
Yes,
Lordship, page number,
Page number 43.
now page number 43. This order was passed on 12 March 2020.
Hmm.
In the meantime, Lordship, that screening process was initiated by advertisement dated first.
No. While the matter was pending before the court, whether you have obtained leave of the court to undertake such exercise,
This was.
whether you have obtained permission from the court.
Lordship, this,
No, you first answer my question.
Lordship.
Whether such exercise was undertaken with the permission of the court while this court is insisting of the matter?
Lordship, to that effect, I have to obtain instruction, but Lordship.
You obtain instruction.
This, this.
No, you obtain instruction then.
Petition is the 5094 of 2013.
Hmm.
But the screening process started by advertisement dated 1st February 2012 and 4th February 2012.
Hmm.
This writ petition has been instituted in 2013,
Hmm.
but the screening process was initiated in terms of the advertisement dated 1st February 2012 and
Hmm.
4th February 2012.
Hmm.
The screening process was already initiated
Hmm.
prior to this institution of this writ petition.
You show that relevant documents that prior to filing of this petition,
Lordship,
the screening process has been started.
Lordship, to that effect, I will obtain instruction and I will produce Lordship. But before that, Lordship, may I take your Lordship once through the select list against which? the
No,
petition
no,
claims
we will
was
not go to the select list. That is not the issue before this court now.
But to that effect, I will obtain instruction.
You obtain instruction, appraise this court at 2 p.m.
Lordship, immediately after petition.
No.
It will be difficult because the department also has to serve the document. Lordship, so Lordship will fix immediately after petition, immediately after petition.
My lord, let it be tomorrow, my lord. Let him get tomorrow in the afternoon.
After, not, immediately after petition, Lordship. Immediately after.
Because
petition.
my
To that effect, I will obtain instruction.
my lord, those arguments he's my lord forwarding your lordships are gone. Already she is found to be validly selected and appointed as tutor. Only but for her qualification not having the NCLT regulation, that's why she is deprived of as a regular teacher. She is appointed a tutor. Once you appoint, you are stable for raising this question before the court. Once you agree, can they raise it, my lord? Can there be, my lord, hot and cold blowing together?
Lordship, in that case, that the very accommodation orders should have been challenged. That should not have been accepted.
No.
That has been accepted. Salary is been drawn. Now
Yes.
at the same time, Lordship,
And interesting, my lord, they are relying on 1974 rules and 77 rules and 74 Act. That argument which I argue before lordships. If there is so, then that qualification 99 will apply.
this accommodation order should not have been accepted in that case, Lordship. It should
I
have been
no, I have accepted that because a beggar cannot be a my lord chooser in the hard days of today. Secondly, my lord, I am just seeking regularization of the post I am holding, tutor to teacher, and payment salary. This my praise is very justified. What more? And let him reply, my lord, whether in 1999, whose rule governed the education? Let him reply that. Let him come prepared tomorrow or the day.
immediately after petition, Lordship. After.
Why not tomorrow?
At 2, my lord.
Tomorrow we'll have some difficulty, Lordship.
Why?
So, I have some personal difficulty, Lordship. Lordship will fix immediately.
If the lawyer difficulty is there,
Lordship.
my lord, my lord,
Fix it up.
just a minute,
On
just
28th.
my lord, my senior used to tell me, if there is any difficulty by a lawyer, you don't oppose the adjournment. Because after all, lawyers, we have to live together. Clients will come and go.
After review.
Okay. Heard Mr. R.P. Sharma, learned senior counsel assisted by Mr. A. Rosid, learned counsel for the petitioner, and Mr. P.N. Sharma, learned standing counsel for the education department, elementary education department. Any other respondent is here? Ms. Cap open for respondent number 5. Heard in part, list the matter in the first week of February, because for the next 2 weeks, this court will not be sitting here.
Lordship. Any day.
Fixed on.
3rd of February.
Human? Development.
May I please your lordship? The matter pertain to the non-payment of area salary, my lord. The petitioner's salary was deprived from 16/10/2015 to 14/7/2022, my lord. The fact of the case is that the petitioner was terminated and thereafter reinstated, and thereafter the petitioner post was regularized by an order dated 14 July, sorry, my lord, 14 July. 16th October 2015, my lord, NHR 12, case 36, my lord. And after case 36, my lord. Am I reading, my lord? In pursuance of the Honorable Guwahati High Court judgment and order dated 6/2/2015 passed in readable number 182 of 2013, batch in the event of miscase number so and so filed by the BTC and consequent upon BTC Executive Council meeting resolution number 4.18 dated 27/4/2015 and Department meeting of Education Department resolution number 4 dated 26/6/2015 respectively, and in consonance with the approval received from BTC, Bhait order dated so and so 16 October 2015, and on being termination order withdrawn by the BTC, Bhait order dated so and so, and on being termination order withdrawn by the BTC, Bhait order dated 16 October 2015, Sri Kalpana Burman, who was terminated from service, Bhait's order dated 3rd June 2009 issued from this and is hereby withdrawn, and his service is regularized, reinstated as assistant teacher in Pub Nalbari Balika LP School in the scale of so and so and grade paid so and so plus other admissible allowance is as admissible under the existing government rule. The regulation of service of the individual teacher shall be the subject to the following terms and conditions. The regulation order shall be come into force with prospective effect, my lord. And secondly, the supplementary demand proposal for the individual teacher has to be made by the Director of Education BTC for onwards admission to the WPT and BC Department of Government of Assam through the BTC for facilitating the payment of regular salary and other service benefit hereto to the person concerned if budget provision is not available as on date. The drawal of regular salary of the individual teacher till 17/10/2006 has to be authenticated by DBO concerned, duly countersigned by the Treasury Officer Nalbari, Tihu, Barangya, Kamalpur, Kokrajhar. The teacher's pension provision will govern as per government rules in office. And the strength of this order, my lord, the petitioner was regularized and she joined in this service, and she is continuing in his service without any break, but her salary was not paid during this period. And suddenly, my lord, another order was passed by the BTC authority, and that was annexure 15A, page 46, my lord. And from this order, there was again issued another order, and that was that in exercise of power conferred upon the Director of Education BTC Kokrajhar Bhait Secretary BTC letter dated so and so 13 September 2005, in pursuance of the approval of the BTC Bhait so and so 14 July 2022, the Government of Assam communicated dated so and so 9/2/2021 the service of Kalpana Burman, assistant of Nobin Kori MESL, who was reinstated in his service, Bhait order dated 16/10/15 issued from this and is hereby regularized as assistant teacher so and posted in Satish Mukha LP School in the scale of pay 14,000 plus so and so grade pay 6,200 and other allowances as admissible under the existing government rule. The said fill-up post has the approval of financial SIU department. The regulation of the service of teachers shall be subject to the following terms and conditions. This regulation order shall come into force with prospective effect. The regulation of the service is liable to be cancelled without assigning any reason thereof if any kind of fraudulent regarding the credentials submitted by the appointee is established by appropriate authority at any point of time in future. The appointee will have to join in his or her place of posting within 15 days from the issue of this order. The teacher pension provision will govern as per government rule in force. from this order, the petitioner is duly regularly getting their salary. But the petitioner is claiming in this writ petition from the period of 16/10/2015 to till 14 July 2022. An affidavit in opposition filed by the respondent authorities.
So, madam, you tell me whether this order, Annexure 12,
Yes,
the first regularization order,
first regulation order.
this was cancelled or withdrawn?
No, no,
No.
not withdrawn. And not even stated that this was a, while issuing the second regulation order, that was not stated that earlier order was cancelled
Mm.
or withdrawn. And the petitioner on the good faith, they were discharging their duties in the strength of this first order. And suddenly the second order was passed that where not mentioned that the earlier order was cancelled.
Mm.
So petitioner is on keeping in dark that they were not appointed in a substantive post. They have she has no knowledge that her service was regularized in a non-substantive post. That is a procedural lapses, my lord. On the part of the procedural lapses, my lord, department, why the petitioner's salary is not paid, my lord. So my prayer is that though the petitioner is regularized after termination, order was withdrawn according to the writ appeal passed by this order, and petitioner has joined in the service and continuously working from 2015 to 22. And in that period, the salary was not paid. And after issuing the second order, regulation order, they have stated that this order has financial approval. Nothing earlier order has not financial approval, not get financial approval from the government of Assam. Government of Assam, they were posted in a non-substantive post, my lord. But that was stated only on 2022, not before that. So petitioner, though the petitioner service is regularized and they are duly working, their service was accepted by the department, so their salary may be given, my lord. They have stated that they were their affidavit that their earlier first order was issued, the regulation order was issued against the non-substantive post. That is their prayer also.
Where is that averment in their affidavit in opposition? Paragraph number?
Yes.
Lordship, may kindly have the additional affidavit filed by the respondent number 4, my lord. Our stand will be clear, my lord, the affidavit.
What is the relevant paragraph?
Lordship, firstly, I would like to say that, my lord, they were appointed as they, along with other various assistant teachers, my lord, they have been appointed as in non-sanctioned and non-existent post, my lord. Thereafter, my lord, Lordship, the learned single judge has upheld the termination of the petitioner, my lord, at page 60, my lord, paragraph number 3. Has upheld the termination of the order of the petitioners by judgment and order dated 21/3/2013, my lord. Thereafter, my lord, a writ appeal was preferred, which was numbered as writ appeal 182 of 2000. And during the pendency of the writ appeal, my lord, a policy decision was taken by the authorities, my lord, for the termination orders. And accordingly, my lord, they were reinstated with prospective effect, my lord. And since, my lord, my lord, as per MOU, my lord, my lord,
no post can be created by the BTC authorities without the concurrence of the government of Assam. And it shall also abide by the decisions of the government of Assam in respect to the abolition of temporarily keeping any post vacant, my lord, as per clause 5.5 of the MIU, my lord. Thereafter, finance has approved, my lord, for sanction of 1,009 posts, my lord, by order dated 2/1/2021, my lord. And after that, my lord,
No, you first tell me whether the first regularization order was cancelled or withdrawn.
lordship, that is not been clearly mentioned, my lord.
They have filed two affidavit, my lord. Two affidavit, but nowhere they have mentioned that the earlier first regulation order was either withdrawn or cancelled. And in their affidavit in page 52, only stated that, however, it is pertinent to mention that the reinstatement of the petitioner so made was not against any substantive post. That was their
In that event, you ought to have withdrawn the or cancelled the earlier regularization order.
Lordship.
Mhm.
Lordship, because these are illegal appointees, my lord. So they, as per the honorable court's direction, my lord, we have taken a policy decision, my lord, in the year 2014. Thereafter, they have
No, if they are illegally appointed, how can the court direct them to be appointed as regular teacher?
mm,
After adjudication of the matter by the single bench, single judge, can you raise that issue again?
um,
Hmm? You have filed a writ appeal and a writ appeal was withdrawn.
yes. No, writ appeal is not done. After hearing the writ appeal, the Honorable High Court judgment and order dated 6/2/2015 passed in writ appeal number 182 of 2013. That's in event of miss case number 183/13 filed by the BTC and consequent upon the BTC Executive Council meeting resolution number 4.1 dated 27/4/2015 and the department meeting of Education Department resolution number 4 dated
Okay,
26
writ appeal was not withdrawn, but it was disposed of by this court.
by this court, division bench. And after that, they were reinstated in her service and the
Mm.
first regulation order was issued, my lord.
The matter has already been adjudicated, and now how can you raise the issue again?
Yes, ma'am.
Okay. We'll resume after 5 minutes.
lordship.
Yes. So it is an admitted fact that the first regularization order has not been cancelled or withdrawn.
Yes, lordship. She
Yes.
was, lordship placed, the place of one retired, my lord, employee. Kutsumi Talukdar, my lord.
Mm.
It's the present petitioner was
Accommodated.
accommodated, yes, ma'am.
Mm. And you are also not disputing that she has been rendering service since the date of her regularization,
Lordship, she has.
that is 6/2/2015.
Lordship, that was illegal appointment, my lord. How can-
No, you answer my question directly.
Lordship,
Whether she has been discharging her duties as teacher or not during that period of time.
that was, she was appointed by the
No.
school managing committee, my lord,
Mm.
at that period, and that was illegal. Supposed to be held as illegal, my lord. So thereafter, my lord, that is why a decision has been taken to regularize their appointment, my lord.
Hmm.
Thereafter, finances.
No,
approved, my
no, since the date of her appointment, she has been rendering her services.
lordship.
You are not disputing it.
That my lord,
Hmm?
my lord, it was they were appointed under non-sanctioned and non-existent post, my lord. How
Ah.
can they be let?
Who had appointed them? The school management committee.
Yes, my lord.
Where is the appointment order? Page number?
Is number. He was appointed in the year of 1999, my lord, page 20, my lord.
Page 20.
And after that, they have received the salary up to 2006, my lord. Thereafter, their service was terminated. A batch of repetition who were appointed in the year of 1999. After termination from their service, and after they approached before this court, and their termination order was withdrawn by the respondent authority and appointed and regularized their service in 2015, my lord. That is the first
No,
order,
she was appointed by Deputy Inspector of School, Nalbari.
Nalbari, in the year of 1999.
So where do you got that they were appointed by the school management committee?
No,
Where?
no, my lord, appointed by the Deputy Inspector of School, my lord.
I have got it somewhere, my lord. In our affidavit.
Lordship, kindly come to the annexure 5, page 25.
Hmm.
That Srimati Kalpana Burman, so village so-and-so LP school is hereby converted to the non-planned post created by the government so-and-so dated 31/12/98. In this connection, Srimati Kalpana Burman, assistant teacher, Put Nalbari Balika LP school, is allowed to draw in the time scale of pay rupees 3,000 so-and-so per plus other allowances as admissible under rules as per order conveyed by the DO so-and-so. The post converted to Srimati Kalpana Burman SM has retained permanently on the letter dated 23/9/18. The expenditure will be debited under the head of account. From this order, she received the salary from 2006, my lord.
Hmm.
From 2006, she received the salary.
Hmm.
And in Annexure 8, my lord, page 29, Office of the Principal Account General, Assam, Beltala. That is that she received, that is the treasury voucher that she received, my lord. Last pay certificate also issued, my lord. That is Annexure 9, page 30. Thereafter, her salary, her service was terminated by the government. After termination, in 2009, it is page 34, Annexure 10, my lord.
Okay, that was interfered with by this court.
Yes,
Okay,
interfered by this court.
Okay.
And thereafter, after that, the government has filed an appeal, my lord.
Hmm.
That appeal, after judgment and order dated 6/2/2015, passed in writ appeal number 182/2013, and the miss case number 183/2013, filed by the BTC, that after the resolution taken by the BTC and the government, they were regularized in 2015. On 16
Where
October.
is that order?
That is Annexure 12, page 36, my lord.
Is 36.
That is the first regulation order where it was mentioned. my lord.
No. That's the order of the division bench of this court in writ appeal.
Writ appeal, my lord. I have not annexed, my lord.
Is it with you?
Hmm?
Can you furnish a copy of that order?
Let me see. Right this time, I don't have, but I will furnish, my lord. I can furnish, my lord. If- My prayer is that though the first regulation order, that is in 2015 order, that was not withdrawn by the government respondent authority, nor it was cancelled. And they have issued another termination order without attributed to the petitioner that they were not appointed in a substantive post, my lord. So they have the fundamental right, my lord. So, but this is a complete case of violation of fundamental right, the denial of salary, my lord, as they are continuously working in the said period, my lord.
Lord, kindly take the additional affidavit, my lord, page 66, my lord, picture 1. We'll take this in paragraph, this is the minutes of the meeting, my lord. In paragraph 5.2, my lord. Without- 2000, Page 66, my lord. Here, my lord, we have stated that the government of Assam has not taken any policy decision for creation and regulation of service of honorary teachers who were appointed by the school managing committee after provincialization of the schools, my lord. So they were initially appointed by the managing committee, my lord. Thereafter, the decision of the after the 1999.
But my lord, my petitioner is not appointed.
Sorry, just bear mind, hold on, Lordship is my associate is doing the matter. But since 99 appointment Lordship is aware of, Lordship, this honorable court, this set aside the order of appointment. And thereafter, BTC also is about taken a policy decision for regularization of this service. Lordship has come, it has brought into record of this Supreme Court. And for that reason, probably in 2022, again, they have been regularized. Lordship, whether this person belong to same class or not, let me take an instruction from the authorities concerned, my lord. Whether this person, the particular person, Kalpana Borpon, belong to the same class of persons whose termination have been withdrawn by the authorities concerned.
That was stated in the order passed by this court, by the annexure, by the Director of Education, BTC, in first appointment, first regulation order, my lord. Termination order withdrawn. That was stated by the BTC authority. my lord.
Lordship dates and all, my lord, it has in the bit number
182, but
yes, it has brought into record, my lord.
but here the
Then
petitioner was
thereafter,
not,
whether it was regarding with the salary ability,
very excellent.
area salary part, my lord.
From 2015 to 22, that part, as
Yes,
because they were.
earlier, now the government have changed, my lord.
No,
Earlier-
maybe government may change.
Because 10 of the earlier government,
Go, but she has been rendering service.
Lordship,
You are not disputing it.
my lord,
So on the principle of quantum merit,
my lord.
there is one division bench decision of this court and two other decision of Supreme Court on the basis of which they have to be paid for the service rendered by them.
Because new government has come in recently, maybe the steps have been taken. Even as a council, although I'm doing matters for the petition most of the times, my lord, if the service has been utilized, they should be paid their salary, my lord. That is my own view, my lord. Lordship, I may take instruction from the authorities concerned, my lord, whether this government has taken any steps regarding payment of area dues to the petitioner. Because earlier set of, Lordship, earlier government has taken a decision not to pay to them, your lordship, regarding area salary part. Whether the present BTC government has taken any steps regarding the payment of dues, because during their regime, the termination orders have been withdrawn, my lord. No, I don't.
No, they are not, this is a, yes, termination order was here.
BTC Hagrama Thakur বস্তু withdraw করেছিল।
But it was,
Yes, yes. So it may go in their favor. Let this matter be taken up. View holidays, after the view holidays, I will instruct him. Lordship, I have fully, Lordship, agree with your Lordship's view, my observation, that if the services have been utilized, they should be paid their salary. If not from the government, but from the authorities concerned who have given the appointment, although their appointment may be illegal or irregular. That is my personal view, my lord.
So the division bench of this court two thousand sixteen, three ZLR 198.
Lordship, may I, 2000?
16. 3 ZLR 198.
My lord.
State of Assam and others versus Orunima Setia. This is a division bench. And one decision of Supreme Court, very recent, Mansingh versus the state of Uttar Pradesh through Secretary and others, reported in 2022 Live Law SC 341.
2030.
2022 Live Law SC 341.
My lord.
And another decision of Supreme Court, Sukhdev Pandey versus Union of India, reported in 2007, 7 SSC 455, page number.
My lord. Lordship will go through it in the middle, I'll take, Lordship, instruction from the authorities concerned, my lord.
Okay.
Immediately after we all, let this matter be getting partners, my lord. Already partners.
Already
Heard
part of-
Ms. A. Buzargura, learned counsel for the petitioner, and also heard Ms. B. Bunya, learned senior counsel. Come, standing counsel for the BTC, assisted by Ms.
No.
Bora, learned counsel for the respondent. Heard in part, place the matter
Detail provider.
as parted in the first week of February,
4th of February.
part of February. Okay.
Let's.
Oh, 4th of February.
Item 5.
We have to get the finance department who are ready to take instructions. And we are ready for.
No, not actually instruction, Lordship, whether the excess amount has already been recovered or not, Lordship. It is recovered, Lordship. It is recovered, Lordship. I have,
Any document with you?
yes, Lordship. This is the instructions from the treasury officer to the bank. And from two heads, it was recovered, Lordship. Lordship, area of pension was, Lordship, 6 lakhs, Lordship, 256 rupees, Lordship.
Hmm.
From that, Lordship, 2 lakhs, Lordship, 6,742 was recovered. Again, Lordship, the CRC sanction, Lordship, 12 lakhs, 64,652. From that, Lordship, rupees, Lordship, remaining amount was
Finance
recovered.
Covid. Soliha?
Recovery হয়ে গেছে।
Lordship, as per my instruction, the recovery has been made from the petition.
Recovery has been
Yes,
made.
Lordship. 12 lakhs from the DCRG and 2 lakhs from the area,
Area pension.
roughly, Lordship.
Hmm. And he is also not a gazetted officer.
Yes, he's a Lordship, I am actually awaiting some instruction regarding if we can find out from official chart from which grade he belongs to, Lordship, whether, grade 2 or. grade
No,
3.
admittedly, AG has not issued any payslip to him.
Lordship, yes. Maybe perhaps because of that, the treasury officer is not in a position to comment on that, Lordship.
Hmm. Now the question is, are they entitled to recover the amount?
Lordship,
Are they entitled to recover the amount?
Lordship, that will be I think that is the subject matter of the petition, Lordship.
Hmm.
The recovery has been made on the last date, Lordship, the query was raised whether the recovery has been made or not.
No, that's all right. But now the question is, in view of the decision of Rafiq Masis,
Yes, Lordship.
are you entitled? There is
Lordship-
also one notification of the finance department.
Yes, Lordship, here,
After the, not finance department, it is
the
the
pension.
notification issued by the chief secretary perhaps.
Lordship. Yes, Lordship, only, Lordship, one instruction which I'm trying to, whether if in any way we can show that whether he belongs to grade 3, grade 2 post, Lordship. So that instruction is awaited.
That instruction has already been furnished by the Accountant General, Lordship.
Instruction.
The Accountant General has.
Yes. Great.
As per state instruction, I place that later.
We have not issued any inspector during his service period. Because he retired as an enforcement inspector. And if you onwards, Lordship, we are issued.
কবে এইটো চিফ সেক্রেটারি নোটিফিকেশন খন আছে রফিক মাসেস পিছত এই রিকভারি এক্সেস রিকভারি এটা দিছিল নেকি ৰাখিব So Talukdar, you has produced one letter.
Yes,
Do you have any copy of the same?
I have the original one.
Original. Okay. And admittedly, the person concerned was not the drawing and disbursing officer at the relevant point of time.
At that point of time,
Yes.
but he was holding the post. Some point of time he was holding the post in paragraph 6. of
No,
chapter
we are only concerned with the relevant period when the excess amount was drawn by him.
Yes, at that point of time, he was not the person concerned.
Then can you made him responsible for the same
My.
in view of decision of that Rafik Masis case?
Yes, but Lordship, my mistake is that since he's well aware of the fact, he's knowingly drawing the excess salary. So Rafik is not applicable in this is my stand. So paragraph 6 and 8, I'm relying, it's already Rafik already observed, madam. And as for the notification of 2003, he's holding the grade 2 post. This is the stand of the department in paragraph 8, madam.
In response to that, Lordship, I have filed my reply affidavit, Lordship. Paragraph number 3 of my reply affidavit. I was in charge DTO, Lordship, with effect from 18/7/2019 to 29/10/2019, Lordship. And Lordship, wrong fixation was done, Lordship, with effect from Lordship 1/4/2016
31/8/2023.
to 31/8/2023, Lordship.
Those were from the.
That is till the
16.
till the date of
Detail 2019, Lordship. That may be also.
formal lot 2 months, Lordship, in charge DTO 18/7/2019 to 29/10/2019.
The person concerned is written from 14/11/2022.
In which paragraph of your affidavit you have mentioned that he had the knowledge about the same?
That's the paragraph 6, madam.
Paragraph
Right,
6.
75.
Okay.
The lordship, in the writ petition, page 44, the service book, the signature of the petitioner is also there, that is also mentioned in the last 3 lines of the paragraph 6.
Hmm.
And it's very.
No, you answer my question. Do you have any document to support the contention made in the paragraph number 6 of your affidavit?
Regarding the service failure of the petitioner,
No, that he had the knowledge about access drawing.
because page 44 of the writ petition is very clear. Signature, and it's page 44 to 46. The petitioner signature was there, he was the litigant concerned at that point of time.
This service book was not written by him, but
the-
by his authority.
That's continuous, Lordship.
The authority who has,
In continuation to the earlier notes, Lordship.
yes, but he is.
Mr. Talukdar, please sit down.
Lordship.
Sit down. Yes.
My lord, the petitioner was well aware what he was getting as a salary.
Hmm.
So his signature was there.
There, but this service book was prepared by someone else, not by the petitioner.
Lordship, but we cannot assume that he has no knowledge that he's
Hmm?
getting the excess salary. We can't assume because he's a.
No, assumption or presumption will not do, madam, unless your contention is supported by any documentary evidence.
He's a responsible officer, grade 2 officer,
Hmm?
my lord. That much we can assume, my lord. Ignorance of laws cannot be accepted like that. Ignorance of his
No,
all
no.
details cannot be accepted in this case also.
No. That principle will not be applicable in this case. Anyway, we will see and pass the order.
Lordship,
Yes.
obliged lordship. Lordship, may kindly observe paragraph 6 and 8 as a such a for that.
Okay.
Obliged, Lordship.
Numbers 21 and 22.
One statement in this regarding this matter, Lordship, I just had received some instruction for Lordship, as per the ROP, he falls under class 2, not issued by the AG. Lordship, so in the ROP, he'll fall under class 2. Lordship, I am just trying to get that document, Lordship, I'll furnish that document, Lordship.
Okay.
As per our record, ROP, he'll be in class grade 2, Lordship.
Make please, your Lordship. My lord, in this case, Lordship, I have given all the documents, Lordship, and my learned, just I am coming, Lordship, everything is there. I have challenged the only one notification. One that which I already annexed in my compiled papers, Lordship.
Okay, Mr. Gogoi, what is the stand of the department?
Department here it is a university.
University.
Department is a higher education department.
Okay, technological
The
university.
First statute of the my lord, university, a particular provision has been put to children. Wherever my lord, the NOC is required to be furnished by the petitioner
Hmm.
from the government, for having the affiliation of the university, that has been put to children.
Hmm.
According to them, it is repugnant to the my lord provisions or regulations of the AICT. That is the case, my lord.
And
What is the stand of the university?
But our stand is different. So far as the university.
Referred in-
We go by the regulations and all. I will try to justify whether or not that NOC will come under the provision of the AICT or it will be under the authority of the university to make its own statute and to demand some particular documents to give affiliation to a particular college.
Hmm.
Being the examining authority, because the examination will be conducted by the university. The affiliation will be given by the AICT to the college. And my lord, following the norms, my lord, the educational standard, everything prescribed by AICT, University will, my lord, conduct exam. On that particular area, we have not stepped into that area, my lord. We have not touched it. Which we cannot, because it will be repugnant, and Central Act has provided certain minimum qualifications, we are not into that part, my lord. Only thing is that, my lord, in addition to whatever has been prescribed by AICT, we have sought for one additional document, that is a NOC from the government. And in the present case, my lord, unlike earlier, my lord, lordship has allowed 3 cases, there, my lord, they have applied to the government and it was not received. Here, my lord, they have not even applied, my lord.
No,
They have directly approached the honorable court
I applied, lordship, which was rejected, lordship. Just my lord,
by
one,
the government.
yes, no, by the, yeah, university says that you should bring the NOC. Lordship,
Not been rejected.
his affidavit, page 133,
No,
lordship.
no, NOC has to be obtained from the government.
Government, lordship, which is
Whether
not
you
the.
have applied to the government.
No, lordship, because it is not within the purview of the Central Act, lordship, because 254, they cannot, lordship. Just I have also given all the compiled papers, lordship, of all these, lordship, and my learned friend stand in his affidavit, lordship, may kindly peruse, lordship, 133 page number, in the writ petition, lordship, serial page number 133, lordship. The first one. 2176, page 133, lordship. And that notification also some given in the clause 1, lordship, some protection that if it is against anything, lordship, that the University Act will prevail, lordship. I will come later, lordship. Just my learned friend affidavit, lordship, page 133, paragraph 4, lordship.
Yes.
May I read, lordship, please? The state university is an entity in the concurrent subject of both the state and central government prescribed in the Schedule 7 of the Constitution, entry 66 of the list 1, Schedule 7 of the Constitution of India prescribed the following coordination of so and so. By the said provision of entry 66 of the list 1, Union list, the central government has been empowered to frame acts and rules for coordination and determination of standards in the institution for higher education of research and science, technical education. Likewise, the entry 25 of the concurrent list, which is not list number so and so of the Constitution of prescribed so and so. By the said provision of entry 25 of the concurrent list, the state government has been empowered to frame. My learned friend has admitted, lordship, I am not on that list 25, lordship. I am only on that list, lordship. Rules for regulation of education, including technical and medical education, university, subject to the condition that the same is not repugnant to the act and the rules framed by the central government under the provisions of entry 66, 64, and 65. The next para, that though the AICT Act 1987 has not prescribed obtaining of NOC from the state government for opening up of an institution to impart the course of diploma and UGC engineering and technology PG program. However, the Assam Science and Technology University is in its first statute has prescribed in clause 42B of prior, which is now under challenge, lordship, before your lordship, for prior concurrence of the state government for granting affiliation to a new college by the university, and the same by no means can be held to interfere into the territory of the central legislation. The entry 61 empowers the central government to frame regulation. They have central government have a rules as per the act, lordship. Then last line, the clause 40 only prescribe the conditions for obtaining NOC from the government for obtaining affiliation under the respondent university, and as such, the clause 42B of the first statute of the respondent is valid provisions. But my respective submission, there are this honorable court judgment also. 3 judgments are there, lordship, that in a central response act, the state government have no power to, which is complete violation of 254 of the Constitution of India, lordship, Article 254. And I'm just coming, lordship, in my compiled papers of the new notification, which I am relying, just page 141 of my paper book, Lordship. Big one. That day I had. No, I had given it. It was this on that day I supplied the same. Your Lordship's order is also there. I can pass it on, Lordship, to, I will go through my land copy. May kindly credit the same, Lordship. Come on. Where?
Yes.
Lordship. That is 141, Lordship. Page 42 affiliation, Lordship, clause B. No new college shall be given permission or affiliation by the university without prior concurrence of the state government. Then, Lordship, in the said regulation 1, Lordship may kindly page 121, page 121.
Yes.
Clause C, Lordship, title and comment. The statute are to be considered in conjunction with the provision of the Assam Science and Technology University Act 2009. In case of absence of the provision in the statute, ordinances and regulations, and or in the case of any unforeseen differences or ambiguities in the provisions of the statutes and the act of the university provisions as stated in the act shall prevail, Lordship. So my respective submission, Lordship, since it is duly approved by the AICT, Lordship, as well as by the central government, after doing all the formalities, Lordship, the state government have no authority, which is already held by this honorable court in 3 judgments of this honorable court, Lordship. So I am relying only on that, Lordship, that it is this notification of affiliation regarding no objection from the state government is not at all sustainable in the eye of law, because which is also violation of Article 254 of the Constitution, Lordship, because the state government cannot make any law which is the central subject, Lordship. 250. Just I am coming, Lordship. May I read, Lordship, constitutional provisions 254, Lordship?
No,
the-
not necessarily. There is no dispute regarding the provision.
I am not taking much time, Lordship, on that, Lordship. Since the central government is doing everything, Lordship, only he is an examining authority. For that purpose, Lordship, he is under the central, this petitioner's institution are under the central government, Lordship. Only he is an examining authority. He cannot enforce this provision, Lordship, because in the original act, there is no such provision is there. In the ASTU, Lordship, Assam Science and Technology University Act, there is nothing is there, Lordship, and which this honorable court also earlier on occasions in 3 judgments, Lordship, held that the state government have no role to enforce on that provision of no NOC of the state government. This is my whole contentions before your Lordship, and I already given all the compiled records. Last occasion also submitted the same, Lordship. If that will not get, Lordship, I will supply the copy of my Lordship for kind of consideration, and I leave it while planet, and if necessary, Lordship, I will supply it.
The same institution.
Yes.
They have got the affiliation from AICT.
Yes.
As regards, my lord, the course of diploma and UG in engineering. Possible have a look at the definition.
Page number?
Page 4, page 5, para 4. Paragraph 4 says, my lord, that the
that the petitioner wishes said that for the purpose of starting Amar College of Management and Technology, diploma in UG in Engineering and Technology, and PG degree in Management courses for the next academic session 2025-26. They submitted application before the AICTE. And accordingly, it has been given. So, my lord, so far as this particular case is concerned, my lord, we will be, my lord, we will have to look into the, my lord, AICTE regulations, my lord.
Yes.
Because, my lord, their grievance is that, my lord, after having the affiliation from the AICTE, they applied before the university for having the affiliation from this university being the examining authority. Because the examination will have to be conducted and degrees will have to be offered. So it is the university's part. But before opening a college, they will have to, my lord, have the affiliation from the technical authority of India, that is AICTE, for these particular courses.
Yes.
And it is the AICTE who regulates the entire, my lord, syllabus and all, my lord. What will be the syllabus, what will be the minimum education, how the examination will be conducted, entrance will be done, my lord, how, what sort of faculty will have to be there, what will be the laboratory status, my lord, the library, everything, my lord, what will be the campus, my lord, everything is there. This they who will decide that part. That will be, my lord, as per entry 66 of list 1 of the Schedule 7 of the Constitution of India. That empowers the central government to frame the regulation or say act, my lord. Here that has been done. So now, my lord, so far as the university part is concerned, my lord, university is regulated by the UGC. And, my lord, university, state universities, they have got the authority to give affiliation to colleges for starting a particular institution. Having particular affiliation from the respective regulatory authority of the state, like for medical education. Earlier it was FCI, it is now it is the National Medical Commission. For nursing, my lord, it is the Nursing Council of India. Only the affiliation will have to be there. In the present case, it is AICTE. For the institution to run that particular course. And for examination, it is the university wherever they approach. They have approached the ASTU, my lord, present respondent in the present case. And we have got our own act. Every university is a institution which is enacted pursuant to which is established pursuant to act. So we have got our own act. That lordship will find, my lord. Pursuant to that act, my lord, the first statute has been formulated. Page 47 of the repetition. Thus now he has pointed out the relevant parts. I would like to, my lord,
In my paper, they also write that.
page 47 is the first statute. This has been, my lord, enacted pursuant to, my lord, section 39(2) of the Assam Science and Technology University Act of 2009. At the very top, it has been established. Now, they are agreed by this provision at page 67. Affiliation of civil scheme, my lord. Clause 42. It starts, my lord, terms and conditions of affiliating colleges and recognized institutions managed by the university. They are agreed by, my lord. B. No new college shall be given permission of affiliation by the university without prior concurrence of the state government. This, according to the petitioner, is against, my lord, the norms and regulations prescribed by AICTE. Here, my lord, so far as, my lord, the affidavit, my lord, he has already pointed out. I would like to, my lord, bring to your lordship notice to the UGC regulation first. I have made a compilation to that. Which is not there in the compilation of the petition.
Yes.
Lordship will see, my lord, I have like my tip. This is the University Grant Commission Act of 1956.
1.9.
Yes.
Lordship will see definition 2F. It is a definition of university.
Oh,
University means an university established or incorporated by or under a central act, a provincial act or a state act, and includes any such institution as may, in consultation with the university concerned, be recognized by the commission, that is UGC, in accordance with the regulations made in this behalf under this act. So there are regulations prescribed how a university will be approved or affiliated by UGC. First of all, my lord, will have to be a university which has been approved or affiliated by the UGC. None of that UGC regulation, Lordship will find that in the my lord, UGC regulation 2009. Lordship is in the flag mark, my lord. UGC regulation 2009. It says, my lord, UGC regulation of colleges by universities regulation 2009.
Page 79. Only.
Yes.
Page 79.
Here, Lordship will see, my lord, in the next page, the text, clause 1, 1.2. They shall apply means these particular regulations shall apply to all colleges seeking affiliation and already affiliated to the universities in India, established or incorporated by and under a central act, or a provincial act or a state act. So, my lord, for affiliation is very important, my lord. Says this shall apply to all colleges seeking affiliation and already affiliated to the university in India, established or incorporated by or under a central act or provincial act or a state act. So, for affiliation, my lord, this is the one, my lord, guiding, my lord, regulation
It is not applicable.
by which, my lord, a university will give an affiliation to a particular college. Now, Lordship will see 2.1 definition, affiliation, together with its grammatical variations, includes
2.1.
in relation to a college, we are concerned with a college here, recognition of such college by, association of such college with, or admission of such college to the privilege of a university. So again, my lord, Lordship will say affiliation. It will have to be by the university pursuant to these regulations, not under the AICT. 2.2, college means an institution, whether known as such or by any other name, which provides for a program of study beyond 12 years of schooling for obtaining any qualification from a university, and which, in accordance with the rules and regulations of the university, again, my lord, rules and regulations of the university, is recognized by UGC as a competent to provide for such program of study and present student undergoing such program of study for examination of the award of such qualification. So, my lord, so far as the stand of the petitioner, that it's AICT has not prescribed for having an NOC from the government, while issuing that, my lord, affiliation by the, my lord, AICT, the university can also, my lord, cannot insist for that NOC while giving affiliation in the university. That cannot be, my lord, accepted. That's my humble submission. Now, my lord, this was amended in 2012. That Lordship will see the flag mark, my lord. But I am not relying on that. Lordship will straightway come to the regulation of 2014.
Replies.
Right, this is a notification of 28th of February 2014. May I read the first part? To promote and coordinate university education, including technical education, Lordship will mark these are technical education, and for the determination and maintenance of standards of teaching, examination and research in universities, especially in technical education, and in view of the judgment of the Honorable Supreme Court, number so and so, whereby the authority of All India Council of Technical Education, AICT, Lordship will say, to grant approval to colleges affiliated to universities conducting technical education has been negated. The UGC, in exercise of powers conferred by clause F and G of subsection 1 of section 26, therewith section 2D of the University Grant Commission Act 1926, hereby makes the following regulation. After the Supreme Court judgment, whereby it says that it is the UGC will be the main authority, not the AICT. So far as the affiliation part is concerned, this has been framed afresh by superseding all the earlier 2009 and 12 regulation matter. Now here again, my Lordship will see 1.2. They shall apply to all colleges offering technical education at degree level and seeking affiliation and or already affiliate to the universities in India, established or incorporated by or under a central act, a provincial act, or a state. Then affiliation, my lord, I have already, my lord, read out in the earlier 2009, my lord. 2.3 same, my lord. Commission means the so and so. Then Lordship will see 2.8. Technical education means programs of education, research and training in the areas, namely engineering and technology, architecture, town planning, pharmacy, applied arts, crafts, hotel management and catering technology, computer application and such other programs or areas as the central government may in consultation with the commission by notification in the official gazette declared. My lord, we are concerned with, my lord, engineering and technology in the first case and architecture in the second case. Thus I am pointing out so that I need not to repeat it same. Second case, it is the, my lord, they want to open a college, my lord, for imparting architecture degree, architect, in the second case. In the first case, it is engineering. So, my lord, it comes, my lord, within the definition of technical education prescribed in the regulation of UGC. My lord. That's why I want to point out, my lord. And university means, my lord, a university defined under clause F of the section 2 of the UGC Act 1956 that I already read out, my lord, earlier. Then, my lord, again in the next page, clause 4, mandatory accreditation of technical colleges seeking affiliation, renewal of affiliation from universities. 4.5, lordship will see. All technical colleges which are accredited by NAAC,
Escape.
whose programs are accredited by NBA, shall be considered for permanent affiliation subject to fulfillment of other conditions as laid down by the university concerned. So this gives us the power. And 5.2, lordship will see. If any university grants affiliation to a technical college which does not fulfill the conditions, requirements for affiliation as per the extent UGC regulation, commission shall take such action as it deems is not necessary. Now, my lord, 2 in the next page, internal page 81. Regulation number 2, it says norms and procedure for affiliation by university of a new college offering technical education, change of site, location, closure of a college offering technical education, conversion of a women's college into co-ed education. 2.1 is very important, my lord. A college proposing to offer technical education shall first seek affiliation from the university before starting the academic activities. In the present case, what they have done is, my lord, before having the affiliation from the university, they have admitted the students, they have taken fees. Now they have filed one, my lord, interlocutory application which lordship has still now not entertained. For, my lord, their impleasement, and they want to support the university, stating that we have been admitted because of non-granting of affiliation by the university, we are suffering. But they could not have conducted the selection and given admission to these, my lord, students by taking fees, my lord. In lakhs, my lord, they have taken the fees. It's very clear, my lord. A college proposing to, it says proposing to offer technical education shall first seek affiliation from the university before starting the academic activities. Then, my lord, 2.2.1.2. New college offering technical education shall not be established and not started without prior affiliation from the university. Very, my lord, serious, my lord. How can they violate this norms, my lord? It is there in AICT or private places. 2.2.14. The college shall not permit admission to students to a technical program which is not affiliated by the university. Again, they have given admission, they have taken fees, my lord. This is there annexing the, my lord.
No,
IA.
you were referring to IA, one
Yes,
IA.
that's what
What
I want to
happened?
point, my lord.
What happened to that IA?
No, IA
Is
not
pending,
been-
lordship, not yet
been
implemented.
offered by the because they are not an
Not
SDA
yet
party.
implemented.
Because they have any grievance, they will have a grievance against the college, my lord. How without affiliation they have given them admission by taking fees?
No, that IA was dismissed.
No,
Not-
it is lying till that, my lord. It has
Pending,
not
sir.
been entertained to the extent that, my lord,
Because
they will be allowed.
if main date
Okay.
petition,
It's lying, my lord. Pending, my lord, the consideration of the government court.
Okay.
with due permission, lordship, my learned friend.
No,
He
let
has-
him
No, no, no,
complain.
no,
Sorry.
no.
Let him complain.
Now, lordship will see in the next page 82, 2.2.2, seeking affiliation of the university for. Here, my lord, the petitioner's case will come under 2.2.1A, setting up a new college offering one or more technical education at degree and postgraduate level. Then lordship will see, my lord, page 86. And these things were not, my lord, placed for the honorable court in the earlier three cases. I have checked I will place that. 2.2, 2.2.3.3. Yes, bottom, my lord. Just below the chart, page 86.
Yes.
policy of the state government, madam. The applications for establishing new college and extension of affiliation for existing colleges may be considered by the university concerned as per policy of the state government, madam. Very clear. Then, madam, 110 Lordship will see. Just madam, I just want to point out whether their courses will come under this regulation or not, that I want to point out. Page 110, madam. Serial number 2 in the chart, engineering and technology, they come in within this 110, madam.
Yes.
Serial number 2, engineering and technology, they come under this, madam, they're one of the courses. And in next page, 111, serial number 4, architecture, in the next case, madam. In 112, my lord, postgraduate degree program, M.Tech, serial number 2, serial number 4, M.Arch, that is architecture. So this particular regulation covers this particular courses too, in case of affiliation by the university, my lord, I repeat that again, my lord. Not for affiliation by AICT. Now, Lordship will see, my lord. By regulation, I am placing for both the cases, my lord, architecture as well as, my lord, because it will be the same thing, my lord. In the last flag mark, handbook of architecture of this branch, my lord. It says the approval process handbook. It is there mentioned in the my lord, regulation also. I will point out later in the other compilation of the.
In my compilation, this part is there, Lordship.
Council of Architecture. Approval process handbook, how it will be approved. That is there. So Lordship will turn to the internal page number 8, it is down below, my lord, the page mentioned down below. Page number 8, it says grant of approval. Regulation, clause number 4. Here, the relevant will be Lordship will. Internal page 15, my lord. Clause 4.4, setting up new institution.
Yes.
Page
Page 15, my lord. At the top, clause 4.4, setting up new institution. New institution shall be required to apply online for introduction of VR program and upload the documents required as follows. Here, serial number 5, Lordship will kindly see, because NOC is only the issue that I want to point out. 5, application receipt shall be processed as per the norms and procedures specified in the approval process handbook. That is this book. The institution shall also have to adhere to the existing central, state, Lordship will mark, my lord, state and local laws and norms of other regulatory bodies, such as affiliating university also if applicable. State as well as the affiliating university, all will have to be looked into. It has been prescribed in the handbook of approval issued by the School of Architecture. That is the main regulatory authority of India for architecture. May I read it again, my lord? 5. The applications received shall be processed as per the norms and procedures specified in the approval process handbook. The institution shall also have to adhere to the existing central, state and local laws and norms of other regulatory bodies within brackets such as affiliating university. We are the affiliating university in the present case because they have applied before us. And then Lordship may have a look at the compilation of the petitioner now. I have not repeated the same document, so I will rely upon this compilation here.
No, it is the same document, why?
No, it's not the same. That's why, my lord. Whatever is not there in my compilation, I will rely upon this. I have not repeated those documents. That's right. Now, Lordship will see, my lord, page 13. AICT Act of 1987. This relates to the, my lord, first case regarding technical education. That is engineering. Page 15, lordship will see. The definition part, definition 2G. Technical education means programs of education, research and training in engineering, technology, architecture, town planning, management, pharmacy, applied arts and crafts, and plus other programs or areas of the federal government may in consultation with the council by notification in the official gazette declare. Now, technical institution means an institution. Lordship will again mark this part very important. Technical institution means an institution not being an university. Means a college which offers courses or programs of technical education and which includes such other institution as the central government may in consultation with the council by notification in the official gazette declare as technical institution. So, my lord, by this exclusion, lordship will see not being a
Indian
university.
Council of
Means, my lord, this AICTE Act will not, my lord, regulate the university. It's only those colleges which seek for affiliation from the AICTE that will be regulated by this act. Not being a university, lordship will mark this. Technical institution means an institution not being an university which offers courses, programs of technical education. Then, my lord, page 26.
Page 26.
This is the All India Council of Technical Education grant of approval for technical institutions regulations 2020. Means AICTE grant of approval of technical. My lord, this particular regulation is for granting of approval by the AICTE, my lord, for technical institutions. 1.28 page 27 says, my lord, 1.28.
And 120 notifications are given.
Setting up a new technical institution. So they are setting up a new technical institution. So, my lord, the AICTE approval is necessary.
Already as AICTE has given approval.
Now, lordship will see 1.4. In compliance to the order dated so and so passed by the Honorable Supreme Court, page 28 of the compilation. 1.4. In compliance to the order dated so and so passed by the Honorable Supreme Court in CA number so and so for the institutions intending to offering courses in architecture program. Approval by the Council of AICTE is mandatory. However, interested institution may also apply to AICTE for approval. Now, 2.7 speaks about the approval process handbook. It's a handbook published by AICTE prescribing norms and procedures for processing of applications submitted for granting of various approvals from time to time. So that I will place, my lord, it's part of this compilation.
Okay, Mr. Gogoi, we will resume after break.
Lordship.
Yes, Gogoi.
May it please the lordship. My lord, I apologize for intervening. My lord, there's an item number 9 and 10. Hearing matters. My lord, it may not be possible to do these matters. I have some difficulty today. Can it be taken up on 29th of January? 29th January.
Parthad matter, but this court has to release the same because for next 2 weeks, this court will not be sitting here. I have benched at Kohima.
My lord, when next sits also, we will ensure we'll make a mention before your lordship. If your lordship is taking up civil bench one, we'll take it. We'll make a mention for that. 29.
Okay, as agreed by learned advocates of both the parties, rest is the matter on 29. Okay.
29. 29 January. Fix the obligation.
29. Why don't we have a picture for compilation?
Yes, yes. We were in point 2.7,
Well,
approval of the
yes,
approval
now-
process of handbook.
Page 31 of the same one.
31.
Yes. 3.1, madam.
31.
Yes, 3.1A.
Yes.
31, 3.1A.
Mhm.
It's same as melody in the UGC regulation, here also in the AICT regulation, it has been stated. The new technical institutions, either by the government aided or self-financing institution, that is the petitioner, shall be started only after obtaining approval of the council. Here, my lord, without obtaining, but before, my lord, that by only taking approval from the council, they have taken the admission in violation of clause C and D. Now, Roshi will see C. In no eventuality, a technical institution without approval of AICT and affiliating university concerned shall be allowed to participate in the counseling and admission process to admit students. They have admitted, they have taken fees. D. The affiliating university or board shall not enroll students admitted in such technical institutions which do not have equivalent prior approval of the council.
Mr. Gogoi, the issue before this court is whether they have rightly admitted the students in their courses or not. That is not the issue.
No, even my,
Oh,
my
yeah.
they are malified part, my lord.
Mm,
They don't want to apply for the NOC from the government.
mm,
And here, my lord, without having approval from the university, they have started, my lord, taking admission.
mm,
They are aware that they are still, this petition is pending, my lord.
mm.
They have not got the approval.
The issue before this court is whether NOC of the state government will be required or not.
No, that's why I want to point that is there in the my lord, regulation. That's why I'm pointing out. Because I have been preferred.
Mm.
Now, Lordship will see. Regarding NOC part, my lord, I will point out.
Mm.
Now, my lord, page 47. This is the amended, my lord, AICT, my lord, grant of approval for technical institution regulation of 2021.
Mm.
Here I would like to point out. This here. Yes, but in this amendment, there is no nothing of the problem. But Lordship will now speak. Page 55. The latest one, madam, the approval handbook of
Mm.
now All India Council for Technical Education grant of approval for technical institution guidelines 2024-27. This is the my lord,
Mm.
latest one.
Mm.
Here, Lordship will speak. Page number 63, 4.7.
Mm.
Requirement for the new and existing institution deemed to be university conducting technical programs.
Mm.
Here I would like to refer to D in the next page 3.
Mm.
NOC from affiliating university, board, state government shall be required as applicable for such applications as specified in the approval process. NOC, it has been otherwise mentioned in the regulation of 2024 to 27. There is a
Mm.
latest one. Then again, my lord, page number 68.
Mm.
Processing of the application and grant of approval.
Page number 68.
Page 68. 6B. The AICT. The page, my lord,
Important paragraphs.
B. AICT gives approval to institutions based on the compliance of the norms and standards prescribed by the council from time to time. Now, this line is important. It is the sole responsibility of the institution that the petitioner has to get permission NOC from the government affiliating university board. This is there in the regulation of 24 to 27 of AICTE. Then again, my lord, this has been reiterated for the existing institution also it is required, but they are not the existing institution, they are new.
No, Mr. Gogoi, you say to get permission stroke NOC from government stroke affiliating university stroke board.
Yes. Plus NOC from government. So NOC from the government, that is the whole issue. They are saying that it is not there in the AICTE regulation or in the my lord, regulation of the School of Architecture. So we cannot my lord, incorporate it my lord, in the our regulation or the first statute of the university to have a NOC from the government. I just want to point out that my lord, it is written in their AICTE regulation itself, which is a central regulation. They say that my lord, it is an occupied field. We are trying to intervene in that occupied field, my lord. Then Lordship will see the handbook now. The approval process handbook 2024 to 25 to 26, 27, page 81, AIC. These were not pointed out, my lord, in the earlier two cases. That's why I'm posting it. Otherwise, it would have been a covered case. Page 81. Approval process handbook at the top, AICTE. My lord, I would like to refer to page 91. Clause 1.4.5.
Flag marao, flag लगाओ.
All the applicants shall submit a copy of the application to the state government, union territory, and affiliating university board immediately and get a receipt from the official seal from the authorized signatory of the same. So, my lord, it's required. AICTE gives, my lord, 1.4.7 gives approval to the institution based on the norms standards prescribed by the central by the council from time to time. Again, my lord, to get permission from the state government, affiliating university board is the sole responsibility of the institution. So they are saying that, my lord, regarding affiliation from the government or from the, my lord, university, it is the responsibility of the, my lord, institution. They have nothing to do on that point. They are not the regulatory authority of the university, my lord. This line, my last line, to get permission from the state government, plus affiliating university, we are concerned with the affiliating university, is the sole responsibility of the institution. They have nothing to do with that. And my lord, for granting the affiliation by the AICTE, they have laid down certain criteria that they will have to fulfill, and they have fulfilled, and accordingly they have given the, my lord, they've been given the affiliation by the AICTE. Now what is required is to run the institution and to conduct the, my lord, academic session. They will have to have the affiliation from the university. There only one condition is left, that we must have a NOC from the government. They have not even applied, my lord, straightway they have approached the Honorable Court stating that this is repugnant to the, my lord, provision of the Central Act. That is the AICTE regulations. And interestingly, my lord, in the present case, unlike in those three cases, we have been referring, my lord, vehemently. There, my lord, UGC was a party, SCRT is a party wherever necessary, Bar Council of India is a party, who are the main regulatory authority. In the present case, neither, my lord, AICTE is a party nor UGC is a party. To clarify this particular position, there they appeared and they clarified. Here, my lord, they are not a party. I don't know why, my lord, same petitioner for different courses. Particularly, I will point out those judgment, it is part of this compilation. They were party. They opposed it on they duly, my lord, participated in the proceeding. They filed their affidavit. They clarified whether that is required or not. Here, my lord, AICTE is not a party. On that point, for non-necessary party, this particular petition I will be dismissed. Because without that, those necessary parties cannot be adjudicated upon simply or based on certain documents. We are starting to interpret it. In the absence of the authority who has issued those regulations, my lord. This Lordship may kindly note this for me. I will point out in the earlier orders that they were party. Same petitioner, they have been made party in those cases. Here, my lord, interestingly, why I don't know. They have not been implicated. Now, my lord, coming to those judgments, what you will see in the compilation one, I have already pointed out. In the UGC also, it has been stated, my lord, in the AICTE as well as, my lord, in the handbook of the School of Architecture, for architecture, that my lord, so far as the university regulations and acts are concerned, that will have to be followed. They have clarified everywhere, my lord. For affiliation by the university, you will have to follow them. Now, page 193. This is the same petitioner that he has been referring to, that he has got a favorable order. 193, it's by the WPC 3782 of 2022. This is regarding my lord, the LLB degree. They have one institution of law. There, my lord, that NOC of the government was not granted by the Guwahati University. There they have applied before the Guwahati University. And my lord, for that they approached the Honorable Court. Now, Lordship will see page 193 is respondent number 3 and 4.
No, that is there.
Yes. Here, my lord, they are not the party again, my lord. UGC or the AICT or the School of Architecture, who are the main authorities, my lord. Now, my lord, coming to page 195. Lordship will thus I want to point out what was the case there. Para 3, Mr. So-and-so, counsel for the petitioner submits that the petitioner is a non-governmental organization registered under the Societies Registration Act, as well as Companies Act, and with a view to start a law college to start LLB, BA, LLB, H degrees. It has submitted application to the respondent number 2, that is the university, as per norms of the PCI, that is Bar Council of India, on 31/3/22 to the Guwahati University. That is the respondent number 2. But the respondent number 2 has not taken any action upon the application filed by the petitioner, and subsequently the petitioner filed another application on so-and-so, seeking provisional NOC as well as affiliation from the respondent number 2 get approval from PCI for running LLB and BA LLB honors courses, as it is mandatory to submit the copy of the affiliation obtained from the university concerned to the PCI at the time of making application as per provisions of Rule 6 under so-and-so. Now again, Mr. Mohanto submits that the respondent number 2 by a common notification, it is the university's notification, that the 24/5/2022 notified all concerned that the university will accord permission to open a new college stream subject after obtaining NOC from the government by the respective institution. There the case was, my lord, it was a notification that was issued by the university, Guwahati University. In our case, my lord, it is a statute, my lord. It is there in the statute, not a notification or an executive order. There is a fine difference, my lord, between the factual position of this case as well as the present case that Lordship is taking up today. There, my lord, it is there in our first statute. It has been passed by the assembly, not by some, my lord, registrar of the university. It's a statute passed by the assembly of the state. Now, my lord, coming to page 196. With a further request to all concerned who have applied for the same, but still pending for a decision to submit government NOC in the Office of the Director, College Development Council. But Ms. So-and-so submits that the notification dated so-and-so was issued by the respondent number 2 on the basis of one OM issued by the government of Assam, and the said OM is not applicable in the case of the college being proposed to be started by the petitioner in a private funded college, and that being so, refusal to give permission to the petitioner college amounts to contravention of the existing laws occupying the field, and as such, the action is arbitrary so-and-so. So this was the standard. There was a government notification following that an OM was issued by the university. That now you will have to have the NOC. But my lord, in their first statute or their act, my lord, it has not been amended. It was just an executive order stating that government has asked, now you will have to give. On that, Lordship has said, my lord, this is not permissible. Lordship will see now, my lord, the stand of the university, page 198, para 7. Thus, I want to point out, my lord, what was their share. Only one short para has been reported. Learned Counsel for the respondent 4 submits that as per Bar Council regulation, if necessary, NOC will be required at a later stage, and as per respondent 2 has to grant affiliation. Now, this has been admitted that they will have to give the admission, and in a later stage, my lord, NOC can be procured. First, we will see the statement that Lordship has reported. This is the statement of the Counsel for the respondent number 4. Submits that respondent number 4 is the, my lord, Bar Council of India. So there they have clarified. Bar Council has clarified that you can procure the NOC later or not. So in the present case, my lord, neither AICT is there, no, my lord, UPC is there, who are the main authority, or the School of Architecture in the second case. Nobody is there, my lord. Yet, my lord, now, my lord, following, placing these regulations, we are trying to interpret, my lord, from their documents, whether, my lord, this will be applicable to us or not. But they are not the authority. Here they have clarified, they appeared, my lord, very categorically, they have stated that, my lord, not necessary. That is Bar Council of India. So here, had the AICT, my lord, been present, they would have clarified, my lord. And we are interpreting, my lord, the regulations.
Mr. Mazumdar,
This is there, my lord, because this will have a further bearing, my lord, in Pan India, because these are central regulations.
so
Central
the
regulations.
Lordship.
AICT and the UGC are not a party. here.
Lordship, my respect to submission, Lordship, our grievance is against only the ASTU, Lordship. We are challenging that notification, Lordship. And we pray, Lordship, I pray, Lordship, before your Lordship, that whether that notification point, Lordship, about regarding no objection certificate of the state government is permissible in the eye of law. This is my only prayer, Lordship. For that, the UGC or others body is nothing, Lordship. We have approved by the Central Act. Approval was given to our college, Lordship. I have annexed the
No,
same.
no, Mr. Mazumdar, you say we have to read all the statutes, UGC regulation and also the AICT regulation. So unless they are made party in this petition,
Lordship.
can we
Lordship,
completely adjudicate the matter?
Lordship,
in their
only on
action?
that point, Lordship, whether the state government enforce on the NOC of the state government, Lordship, only on that point, Lordship. For that point, Lordship, the other
No,
aspect,
no, for that issue, Mr. Gogoi has also relied upon their regulations.
Lordship. And that about, Lordship, my learned friend compilation paper, which he has not read, Lordship, that point, Lordship, page 80 of the compiled papers he has submitted, Lordship, regarding affiliation part. Just I am relying, Lordship, on that. Page 80. That is page 79, Lordship, norms and requirement of affiliation, renewal of affiliation of technical colleges by the university. Lordship, page 80. While Lordship 3.1, Lordship, I got it, Lordship, page 80, Lordship, from my learned friend compilation papers regarding university UGC notification, Lordship, which was published on 2014, Lordship. May I read, Lordship? 3.1, page 80, Lordship. While according affiliation, renewal of affiliation to the technical colleges, university shall follow the norms and guidelines as given in annexure to this regulation. These are based on the prevailing AICTE norms and standards. No relaxation in these norms shall be permitted by any university, Lordship. So only that part, Lordship, my learned friend does not refer to that, Lordship. I am referring that, Lordship. Since affiliation was given by the All India Technical Education, Lordship, approval was given by them, Lordship, and only for examining, being an examining authority, Lordship, which was not originally in the act, not mentioned.
Are they only the examining authority? Who will confer the degree upon the student, to the students?
That is the university that asked to, Lordship.
Yes.
So asked to is to grant the certificate, Lordship, because they are the examining authority, Lordship. We want that, Lordship, because that notification of no objection, Lordship, is not sustainable in the eye of law, Lordship.
Maybe,
I have
some reference
Lordship.
To the no objection certificate from the government is there in the AICT regulation and also in the UGC regulation.
That
You
Lordship,
implement them as party, we will hear them.
Lordship, that about, Lordship, in my writ petition, paragraph 18, page 13, Lordship, I have stated same problem was there in the Maharashtra, state of Maharashtra, Lordship. Same NOC of the state government. And there was a judgment of the Honorable Apex Court on that regard, Lordship, 2006, 9 SCC 1. I have collected the judgment from the NET, Lordship. I am supplying that. That paragraph, Lordship, same notification. the state government. And also I have annexed the said Maharashtra notification, regulation of that notification, Lordship. I am just relying in my writ petition, page 44.
No, this decision was earlier referred by the council for the petitioner.
Huh? Party name is Sant Dhaneshwar Shikshan Shastra Madhya Mahavidyalaya and others versus in 2006.
Mr. Mozumdar,
Lordship, please.
it appears that the AICT and the UGC are necessary party in this proceeding. You implement them as party?
Yes.
We will issue notice, we will hear them, and thereafter we will finally adjudicate the issue.
Yes, fine. My respect to submission, Lordship, we want only against, since our grievance is against the state government, Lordship.
No, maybe.
AICT,
They have also relied
With all
upon
respect,
the
Lordship.
regulation of UGC and the AICT.
Lordship. And other cases, Lordship, please, Lordship, in the other three judgment of this honorable court.
Maybe, there, in those three cases, all the parties were before this court.
I can flip, they are parties. In the third case, my lord, National Council of Teachers Education, NCT.
NCT is not required, Lord, for anyone.
No, here not required.
SCRT is a party. They were parties.
Lordship, the Guwahati, the here is not against any grievance against the Guwahati University, Lordship. Our grievance is against the ASTU, Lordship, all Assam Science and
Maybe,
Technology University, for which we are,
maybe
Lordship.
they have relied upon the regulation of UGC and also of AICT. To contend that NOC from the state government is required for granting affiliation.
But Lordship, though they are the party, Lordship, with all respect, Lordship, I am submitting. But this honorable court in three judgment, Lordships, held that the NOC is not required, Lordship. On relying on that, Lordship, I am placing.
No.
Maybe they are not required to, because
No,
already decided
no,
this point,
In those cases,
Lord.
they have challenged one office memorandum issued by the university.
Lordship. And this notification.
Here you are challenging the first statute of the university.
That statute, Lordship, was the,
So there is a difference. First statute and the office memorandum issued by the university are quite different.
Lordship. It is also just that statute frontline, Lordship, just I am taking time, Lordship, your Lordship. Just I am reading that, how this came into existence, Lordship. Lordship, I have annexed in my compilation of papers, Lordship, as well as page 46 of my writ petition, notification. May I read, Lordship, please? Page 46, Lordship. Annexure 7. I annexed in my writ petition as well as in compilation of papers, Lordship. I have also. May I read, Lordship? That notification was on the basis of the Assam Science and Technology University Act, Lordship. Not on any constitutional provision, section Article 309, Lordship. How my learned friend is saying that it was passed in the assembly, Lordship, Assam Assembly. Lordship, may I read, Lordship? In exercise of the powers conferred under section 39(2) of the Assam Science and Technology University Act, Assam Science and Technology University Act, Lordship. Wait. 39(2), may I kindly, Lordship, I am in my compilation papers, I have given that, Lordship. Lordship, my friend will, because I supplied the copy earlier, I don't know where it is missed, Lordship. Wait.
Page number?
No, this company.
Page number, this is it, page to page.
But 39, listed only 150.
Account sponsor. It is 120, Lordship, in my compiled paper, Lordship. Sorry. Sorry. It is a past statute. Sorry, Lordship, I'm just. In the exercise. Oh, I'm supplying the copy of that. It is nothing. Yeah, already given, actually.
Yes, it is the first statute.
Lordship,
Hmm.
just now I supplied the Act, Lordship, of AS2, Assam Science and Technology University, page, Lordship, 32. Which they have referred, Lordship, 39.2. May I read the 39.2, Lordship? Lordship, how this notification passed, Lordship? The first Vice Chancellor shall, within a period of 3 months from the date of his appointment, or which within such longer period not exceeding 6 months from the date of his appointment as the Chancellor, may notify direct and with the assistance of the committee consisting of not more than 6 members nominated by the Chancellor, cause the first statute, the first ordinance and first regulation. That was not passed by the Lordship, State Assembly, Lordship, Cabinet. As per which is mentioned here, section 39.2 of the Assam Sciences and by approval, subsequently approval was obtained from the Governor of Assam.
But it doesn't get a notified matter. Why does?
Maybe.
They have to be-
Let me complete my submission. My lord, on the basis of the section 39.2 of the Assam Science and Technology University Act 2009, that notification came into existence, which was subsequently, Governor is the Chancellor, Lordship.
Maybe, but it cannot be equated with one office memorandum issued by the university.
It that kindly peruse the section 39.2, Lordship, which what the Chancellor came the first statute of and the first regulations of the university be framed and made by the published with the approval of the Chancellor, and the first statutes, the first ordinance and the first regulations of frame shall come into force with effect from the date of such publication, as if they were framed and made under the provision of relating thereto. So, Lordship, this notification was the product of the University Act, Lordship. Not, it is like that what my learned friend is referring in other cases, for which I came before your Lordship.
No. That cannot be. It cannot be read as one office memorandum. Office memorandum is not issued under any act.
Lordship. So,
Better you implement the AICT and the UGCS party. You take step upon them. We know
Lordship,
that some urgency is there, as because you have already admitted students without approval of the university. Maybe, but
we have a approval from the
tomorrow again UGC or AICT will come and file one application that we have not been heard. Therefore, it is necessary to implement them.
correct.
Okay.
So
Heard Mr. K.
may I
Majumdar,
pray,
learned
Lordship?
counsel for the petitioner. Mr. Gogoi, learned standing counsel for the university. And Mr. S. Das for the higher education department. After hearing argument advanced by Mr. Gogoi, learned standing counsel for the university, implement of the AICT and the UGC are found to be necessary in order to deal with the issue being raised in this petition, as they appears to be necessary party in this proceeding. Accordingly, it is provided that the AICT and the UGC be implemented as respondent number 3 and 4 respectively, and notice be issued to them returnable in 2 weeks. Step be taken by
Reopening day. To reopening day, Lordship, or tomorrow? Tomorrow
step be
because may
taken
not
by
be available.
speed post and also by usual process within a week from today. Additionally, dusty service is also permitted. Recessal lays the matter immediately after reopening.
Lordship, it may be remain as part at Lordship, otherwise Lordship entire exercise of valuable time of this honorable court is both of us, Lordship may. So I pray, Lordship, this matter may remain as part. I will serve the copy, Lordship.
Recessal lays the matter as parted.
Much obliged, Lordship.
Item number 6 for orders.
Lordship, can I take back my paper book to
Yes, you
enable
can
me to
take-
make
take
it
it
Xerox,
back.
Lordship, because that part is missing.
But Mr. Majumdar, you say
Lordship.
my staffs have informed me that it was not submitted to them.
Lordship, order is there.
Where?
Last occasion order is there, Lordship. Order is there. I submitted it before this honorable court, Lordship. That,
No, there was direction for submission.
no, Lordship, already submitted. Order is there. Last occasion, kindly peruse, Lordship. I have a copy of that order. It's on paper. Order to us, last order. Prior to one order. Is submitted, has submitted the written arguments with some decision of this court and of coordinate benches and this honorable court, Lordship. Order 16/12/25, Lordship. 16/12/25. Without submitting, Lordship, I may not. I'll make it to Xerox, Lordship, and supply the copy.
And
And-
final hearing, you will submit as a compilation, the same thing.
Before that, I'll submit, Lordship. Because since fire is missing, I don't know. I've
But nowhere, whether in the section or in the bench it is. available.
Lordship, please, I'll not go, I'll make it photostat by tomorrow, I'll supply the same, Lordship.
Okay.
Lordship,
6 orders.
Wait, please,
can I take back the paper book, Lordship?
Yes.
And I'll make it photostat and by tomorrow I'll
Yes.
supply the same with due notice, Lordship, so that it may not be missing.
Mr. Khatunia? It is the responsibility of the contemnor to
Yes.
obtain the proposal.
Yes, sir.
It is his business. This court has nothing to do. This court will only see compliance of the order of this court.
Exactly, my lord.
So this kind of letter will definitely not help you. This matter is pending since the year 2018.
Yes. Matlab it was some more
And even after 8 long years, your contention is that the proposal has not been received
Yes,
from the
sir.
DEO. Who is DEO?
Today, they will give, they will open today, madam. In fact, the soft copy of the proposal has already been received. And hard copy, they will get it today, madam, in the last paragraph. So once it is received in the department, madam, we will verify it and accordingly will submit to the government for necessary sanction, madam. Madam, give me another 3 weeks so that remaining needful can be kept.
Heard Mr. Islam, learned counsel for the petitioner, and also heard Mr. NJ Khatonier, learned counsel for the contemnor. Mr. Khatonier, by producing one letter of the contemnor dated 17 January 2026, submits that the proposal for arrear salary has not been received from the district elementary education officer Dhemaji, and that the soft copy has been received, but the hard copy will be receiving by the contemnors today. And he prays for granting 3 weeks time to complete the process. There is accordingly allowed. Mr. Khatonier shall produce the compliance order before this court on 1st of February. 2nd of February. The letter produced before the court today shall be kept as part, shall be marked as Annexure D and be tagged with the record.
God bless you.
May I please, Your Lordship. Lordship, in this case, Lordship, pursuant to order dated 1811, Lordship, I have filed an IA regarding Lordship's impeachment of this Narayan Kaur, is secretary of the High Power Committee, Lordship. And Lordship, in this main contempt, Lordship, contempt case, Lordship, though this again rejected by the High Power Committee, that order is not still justifiable. And Lordship, that reason is showing that present rejections ground is, Lordship, the enrollment ratio of the student is low. But Lordship, I have to have filed an additional affidavit annexing the attendance of the students. Lordship, that is showing, Lordship, more student, Lordship. In their oppositions, Lordship, it's mentions, Lordship, that students was 51 in the year 1996, and in the year 2008, it's 86. But Lordship, I have filed this.
Sir Khatonier, you have received this application?
Sorry.
You have received the copy of IA?
I have received.
Any objection?
No, madam.
Heard. Mr. Hawk, learned counsel for the applicant, and Mr. Khatonier for the opposite party, for the opposite parties, Alice contemnor. This application is filed by the applicant, the petitioner in contempt petition number 353 of 2024 for impleading Mr. Narayan Kaur, Secretary of High Power Committee, come the Secretary to the Gokta Assam School Education Department as contemnor number 3. in contempt case number 353 of 2024. Mr. Khatunier learned counsel for the contemptor submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. Mr. Narayan Kaur, IAS, Secretary of the High Power Committee, come Secretary to the Gupta Assam School Education Department, be impleaded as contemptor number 3 in contempt case number 353 of 2024. In view of the order passed in IA number 3919 of 2025, Mr. Hawk, learned counsel for the petitioner, shall file amended cause title within a period of 1 week from today, and he shall also take step upon the newly impleted contemptor number 3 by speed post and also by usual process within 1 week from today. Rest shall lays the matter after 2 weeks.
Lordship, even my date, Lordship, as because Lordship, in this main contempt, Lordship, one observation may be given, Lordship, that Lordship, the present rejections ground is showing that enrollment of the student was very low. But
Okay,
today, Lordship, I have submitted.
Okay, let the contemptor number 3 be represented by conducting counsel or by counsel. Director will consider your additional affidavit.
Lordship.
Mr. Hawk also submits that he has filed an additional affidavit, bringing on record the number of students admitted in the school. The affidavit, you have received the copy?
Yes, Lordship. Already.
Mr. Khatunier submits that he has received the copy. Let the affidavit be considered on next date.
Lordship.
For hearing, item number 12.
And for the respondent.
None appears for the appellant on call. However, Mr.
Yes, Burman.
S. Burman, learned counsel for the respondent present. In the event of subsequent non-representation of the appellant, appropriate order shall follow. Place the matter after 2 weeks.
Kindly make it that on 23rd January.
After 2 weeks.
Item number 14.
You are for?
Respondent.
Respondent. None appears for the appellant on call. However, Miss
Yes, Agarwal.
S. Agarwal, learned counsel for the respondent present. In the event of subsequent non-representation of the appellant, appropriate order shall follow.
Document 816.
On 29, January.
Obliged, Lordship.
Item number 16.
None appears for the parties on call. List the matter after a week. In the event of subsequent non-representation of the parties, appropriate order shall follow.
17.
Please, your lordship. You can appeal for enhancement, your honor. The appellant sustained compound segmental fracture of right femur, compound comminuted fracture of the right tibia bone, fracture of the wrist head
It
injury
is
and as a result,
accident case.
accident injury case. Accident. 40% disability.
What are the grounds for enhancement?
My lord, we submitted the yes memo, my lord, about 6,17,000 euro, but only consider 1,91,000 euro. And most of the voucher yes memo were not considered due to the lack of prescription, your honor. And in this regard, your honor, in exhibit 8.1 to 8.10, your honor, page 201 to 210, your honor, LCR. There is a essential certificate regarding internal cost shown as 4,78,804, as well as use of medicine during treatment. The injured claimant and this certificate were properly verified by the doctor of the popular nursing home, your honor. But the tribunal only consider 1,91,000, even not consider the essential
No,
certificate.
unless the case memos are supported by any prescription of the doctor,
Yes, your honor.
can the court consider the same?
Not consider due to lack of prescription, your honor.
Yes, yes.
But we have submitted one exhibit 8.1 to 8.10 at page 201 to 210 TCR, your honor. Second file. TCR page 201 to 2010.
So in which paragraph of the impugned judgment, the tribunal has dealt with that issue?
My lord.
In which paragraph of the impugned judgment, the tribunal has dealt with that issue
The issue
regarding absence of prescription?
No, your honor. Only that there are only two issues, your honor. Whether claimant is entitled to get any compensation as prayed for, and if so, what extent and from whom? And next, to what other relief and reliefs the claimant is entitled to.
No.
No.
Paragraph 18.
18.
18 of the judgment. It will fix that.
In 18, the amount shown exhibit 764 to 769, exhibit 786, 790. There are no corresponding voucher. Exhibit so and so are rejected. There are no corresponding voucher. Moreover, figure of overrating. The million prescription due to the lack of prescription.
It is stated that corresponding vouchers are absent.
Yes. But in addition, that we have submitted the essential certificate for support this case memo, Your Honor, actually. But these are the internal cost. Exhibit 8.1 to 8.10 at page 201 to 210 of TCR. But learned member did not discuss it, Your Honor, and even not consider.
No, the amount may be incorporated in the essential certificate, but
Yes, right.
only because of this, can it be said that the voucher is not required, the prescription is not required?
That this essential certificate for maybe Honor court should presume that this is the internal cost, Your Honor.
Internal cost, that's all right. You produce the relevant document, the prescription issued by the doctor.
The treatment file actually,
Hmm?
there is no prescription, some not issue, Your Honor, only internal person. Because C operation was done in there, Your Honor.
That's all right. We are not disputing it, that he had undergone 3 operation. But where is the supporting documents? Hmm?
The supporting.
Merely because the doctor
treatment
has signed
file, Your
the
Honor.
essentiality certificate, that does not mean that those of medicines were purchased on the prescription made by the doctor.
Hmm.
Hmm?
Treatment file, Your Honor, but
Hmm?
treatment file is not here. Actually, they are reflecting treatment file, Your Honor, but treatment file is not. Not produced, Your Honor. No, not an issue. Actually, they are in treatment file. That
So
is why
unless
we
the
file.
documents are produced, how can the court award the compensation?
Now, the other point also we are now. That. In the judgment, Your Honor, there is no any evidence from the opposite insurer, Your Honor, of the offending vehicle side, Your Honor, but learned tribunal deduct 10% amount on the contributory negligence without any evidence, Your Honor. At para 21 of the impugned judgment, page 14 of the memo of appeal.
So this observation was made on the basis of the pleadings submitted by you. In the document submitted by you, it is stated that the claimant by filing Exhibit A petition before this tribunal stated that at the time of accident, the vehicle having registration number so and so was driven by him. And he himself is the owner cum driver of the vehicle.
Charge sheet is filed against the offending vehicle, Your Honor.
Hmm? Both the vehicles were involved in the accident from front side. There was head-on collision. Therefore, the tribunal has held that it is the claimant also contributed his negligence to some extent to that accident. So it is on the basis of the petition submitted by you, which is exhibited as Exhibit 1, Exhibit A. How can you submit that there is no evidence? Exhibit 1A is your document.
These subject document.
You see the language of paragraph number 21.
21, Your Honor. With the charge sheet is filed against the offending vehicle, Your Honor, not us. Evidence on the report. Evidence on the report. Evidence.
So these are the two grounds.
No, only another ground is there. The interest is also not awarded by them.
Interest 6% was awarded.
Not awarded, and no any interest awarded.
Hmm?
That's in the impugn judgment, Your Honor.
Interest not awarded.
The opposite party to United India Insurance Company is directed to pay to so and so rupees only to the claimant as compensation within 60 days from today, failing which an interest
6% per annum.
only failing. It is not interest.
Hmm?
From date of filing, Your Honor. Only failing within 60 days from today, failing which interest at the rate of 6% per annum be calculated from today on the awarded amount until realized.
Not from the date of filing of the claim petition.
Yes.
When the claim petition was filed.
Year 2008, Your Honor.
2008. 8. And when you have filed your evidence in affidavit before the tribunal?
On 9/3/15.
9/3/2015.
15.
Nine 3/2015, and the judgment was delivered on 21/7/2015. So what wrong the tribunal has committed? Since 2008, you have failed to file your evidence in affidavit
In the meantime,
till 2015.
now it is amended the claim petition, Your Honor, and made the party. Our vehicle also made party, Your Honor.
Hmm? Yes, madam, the
My
interest
lord,
would have
my-
been paid
my-
from
my
the
lord-
date of filing of the evidence in affidavit.
At least that, okay, Lordship, but 7 years they delay. Lordship is
7
very
years
correct.
delayed.
All the right questions Lordship is putting, my argument is covered by Lordship questions only. So Lordship, that is okay from 9/3/15, Lordship can give the interest till, I think we have already paid and they have, Lucy, no? They have already taken, so till that date, till the date the insurance company paid the amount, Lordship.
And regarding this houses,
Lordship correctly said, how can there be Lordship? Lordship, I think what.
no, his contention is that though there is no prescription, yet he has submitted the essentiality certificate.
Lordship, he was a government official. He is a government or not was, he is a government official. Maybe he has taken those amount from the, he has. No, let me finish.
No,
Lordship, the evidence of doctor is also not deduced in the case to prove that those. So, and that does not cover the certificate, the prescription part, Lordship. It
No,
won't
all-
cover, just a certificate from the doctor that this doctor did not sell them.
would prove the disability, Your Honor.
And disability, about disability, Lordship, it is clear, Rajkumar Ajay Kumar, he is working, Lordship, the court has discussed that. At paragraph 19, Lordship. And regarding this vouchers, Lordship, in fact, they do not have a ground. They have not formed any ground. And the second also, what he submitted for that also, there is no ground about the interest part. About disability, he has a ground, Lordship. And also pain and suffering, he said that pain and suffering is not given, but it is given in the judgment. And the disability ground, Lordship, paragraph 19, Lordship, I would like to refer to 19 of the judgment, the disability. As per exhibit 5(1), the claimant was admitted at Popular Nursing Home, Patna on 6/5/2007, and he got discharged from the hospital on 14/6/2007. That is, he was under treatment at hospital for 38 days. Therefore, the claimant is entitled to get special diet allowance. So this tribunal awarded a lump sum amount is 4,000 as compensation towards the special diet allowance. There is no evidence on record to show that due to his 40% disability, which is not permanent in nature, he faced any difficulty to do his normal work. It is an admitted fact that the claimant is working as an extension officer, in short EO, under the Directorate of Panchayat and Rural Development to the government of Assam. So he has no loss of income during and after his treatment. The claimant has not produced any document to show that he was not getting salary from the government during the period of his treatment. Therefore, it is clear that he was getting salary from the government during the period of his treatment. There is no evidence of record to show that the claimant found himself difficulty any work in his office as well as in his home. So question of determination of 40% disability for awarding compensation does not arise. So Lordship, this is as per Rajkumar Ajay Kumar, Lordship knows it. I can submit Rajkumar. Lordship knows because I did earlier also. Lordship knows that. So loss of income itself is disability itself is not loss of income. And in this Rajkumar Ajay Kumar, the example is also given of a working person, one who is working in the office, Lordship. There will not be any loss of income for that. So, and the paragraph 13 of Rajkumar Ajay Kumar, we may now summarize the principles discussed above.
That's all right. Since he is a government servant, there was no loss of income.
I admitted that he is a service extension officer at the time of accident, Your Honor. No loss of income. Now, my humble submission, there is no any future treatment or other prospect, Your Honor, life enjoyment of life prospect. This amount were not awarded by the learned tribunal, Your Honor.
You, sir?
Future treatment.
No, whether there was any evidence to show that he will need future treatment.
No.
And future prospect is.
But the question of future prospect does not arise here.
So
Oh,
now the
user
when
treatment,
when a person is suffering from 40% disability, you know, that is
40% disability,
Yes.
whether the doctor was examined to show that you have suffered 40% disability and whether it is permanent or temporary disability.
they prove the certificate by
Hmm?
all the officer, official.
No, whether mere exhibiting the document is sufficient.
And this disability is duly constituted medical board, issue the disability certificate, Your Honor.
Hmm. No, how
And
the
prove the
disability,
documents, Your Honor, regarding their.
how the disability has to be assessed and how the disability certificate has to be proved. That has been discussed in the case of Rajkumar versus Ajay Kumar. Have you gone through that decision of the Supreme Court?
Karate and so on. Hmm? Medical.
Paragraph Lordship, later on that I read, later on the court has mentioned about PW3.
Right.
PW3, Kalindra Datta in his cross-examination himself admitted that he cannot say what is locomotor disability. He has no knowledge about it. He was not present in the board meeting. He cannot say as what part of the body the claimant got 40% disability. It is their witness, Lordship. And court has given a reasoned judgment, Lordship. Court has mentioned the evidence.
So now the issue is whether on the basis of essentiality certificate, in absence of any prescription, we can enhance the amount or not.
Now. Okay. Now, my humble submission before your lordship is that the claimant was as indoor patient, Your Honor, about 56 days, Your Honor. So in the internal cost, Your Honor, when he is an indoor patient and 3 operations were done there, Your Honor, so there is a sufficient expense will be incurred, Your Honor.
Let us keep the matter as parted. In the meantime, you find out if some decisions are available on the point of essentiality certificate.
Okay, Your Honor.
If we can consider the essentiality certificate to enhance the amount. Part Mr. N.D. Soduri, learned counsel for the petition, appellant.
Essential certificate, my lord, no any other documents except essential certificate. Only
Okay,
produce the essential certificate.
you produce it, but can on the basis of essentiality certificate, we can enhance the amount or not? You find out some judgment if available on
Try,
next
Your
day.
Honor.
And also Miss Hardy Mazumdar, learned counsel for the
Respondent number 3.
respondent number 3. You are here? Oh, respondent number 3. Heard in part, list the matter in the first week of February. First week of February? Okay, all right.
Item number 18. Is my colleague says it's of February.
Hmm?
10th of February.
10th of February. Okay, as agreed by learned advocates of both the parties, races shall list the matter on 10th of February.
Well.
19. 19.
Mr. K. Gogoi is on lakes in a part-hard matter.
Who?
Mr. K. Gogoi, Lordship.
Gogoi.
Gogoi. Lordship, may I taken up, Lordship, yes, as per my information, Lordship, as he says, after 29th, he is.
The problem is this, I cannot give consent, because he's on lakes.
your lordship will fix it on 19th, that's a possible match, because it's a little bit trouble from the clients. The old matter-
19.
19th, then if they can take adjournment, not, but your lordship will not write that I have given consent. Your lordship will just place that he has adjourned the matter
Today.
today.
And lordship, date may be fixed. We
19th or 19th, I have talked.
again we'll have to take a.
We have talked to, I have talked to him.
যদি পরীক্ষা অমুক এনাকে করছে।
Mr. Towilder, learned counsel appearing on behalf of Mr. Gogoi. Learned counsel for the appellant submits that conducting counsel Mr. Gogoi is in legs in another court and he prays for listing the matter after
After 29th, on 30th or
29th
on
February, it will be on 19th, ballot.
after
in the any first week of February, any date. On first week. Because yes, sir.
3rd February, ballot.
okay. On 3rd of February.
Not.
Mr. Sodori, learned counsel for the respondent, however, opposed the pair being made by Mr. Towilder.
Not it.
Towilder. However, in view of the submission made by Mr. Towilder, the matter stands adjourned to be listed on 3rd of February.
Obliged.
May I please lordship. In this case, I'm the appellant, I've challenged the impugned judgment. So my lord, I took time earlier also. I took time earlier occasion also. So I need some two judgment also. Today I got it. I could not find out from this. So my lord, I've taken the plea ground in my appeal. If lordship in fixed on another day. Because there is a vehicle involved in the accident, my lord. And there is my lord, owner and driver also appear. They file in WS. But in the MBI report, there is no reflection regarding the permit. So since there is no reflection of permit, even then they have not submitted the document by the owner. It is their mandatory provision. They have hide because at the time of accident, the offending vehicle has no permit. This is very important. So that is why I could not take defense. Where from will get it? We'll get it from the MBI report. That is blank. That was blank. Permit is very important.
It was a commercial vehicle?
Yes, my lord. A Tata Sumo, my lord. That is a motorcycle and Tata Sumo. Two vehicles involved in the accident and there is a head-on collision. Although charge sheeted against the Tata Sumo.
You were the insurer of Tata Sumo.
I have order not parking the appeal, my lord.
I have taken the step, but they did not turn back. If lordship necessary, I take by paper publication.
If demo of parties, my lord, there is no method about this owner and driver of this vehicle. Fancy demo of parties, my lord. Now they are.
Yes, there is a party in the memo of appeal. Kindly see 2 and 3.
No, their names are struck off.
No, that is why struck off.
They cannot pick, my lord.
No, that is the thing.
No, that is the thing, my lord. My lord, allow me, I'll take the paper publication within a.
No, after,
No, lordship, that is my submission. That is the submission. It is my submission, or I have taken number of steps because this case was filed with delay application. During the delay application, I have taken the step, and thereafter also I have taken the step by both ways. Then lordships, they have submitted, my lord, it is a delay case, not necessarily struck off. Whatever may be. Now, if the question arises from the other side, so I'll take paper publication for the interest
no,
of justice.
Mr. Pal,
Yes, my lord.
this
For the-
order dated 23rd
Yes, I- I-
and
I know,
2019
Yes.
reflects that at your instance, the name of respondent number 2 and 3 are struck off. Now, can you again submit that you may be permitted to take step upon
For
them
the
by
interest
paper
of justice, my lord.
publication?
The interest of justice, because
What interest of justice?
because I have pleaded that is the permit, regarding the permit, because they were appeared in the lower court, but they willfully not appeared in the high court. From the notice of the summon of the lower court, they appeared, they submitted WS. On the basis of that aspect, I have argued the matter. Or on the other hand, because in the delay application, I took step as per the order of the court, they did not turn up. Even then, in the appeal, I also taken the step. Because of hurriness
No,
of
no,
the,
that is so, you cannot again raise before this court.
my short time may be allowed within a 7 days, I take step, my lord, for paper publication.
No, no, no. At your instance, he was, their names were struck off from the,
My name is that I agreed, I admit.
no.
And the question is that, my lord,
No, no,
otherwise
no,
I'll be
no.
prejudice. At this FAK, my lord.
You cannot change your stand now.
No, that is why, my lord, I'm saying, on the basis of, that time was recorder was not come. Recorder was not come. When I go through the record, then it is reflected. Because in the company, my lord knows that there is a no
No,
record.
no.
On the basis of that, only the minimum record, I took this fee. Then ultimately it has come that there is a no, I have the no MBI report.
Okay, you come prepared, we will hear the matter in the first.
And if you allow me, my lord, at the last chance, I take paper publication.
No. Not permissible.
This is limited, my lord.
Not permissible. You come prepared, we will finally hear the matter in the first week of February.
My lord, 12th of February.
As agreed by learned advocates about the parties, this is always the matter on when? 12 February. 12 February. On that day, an endeavor will be made to finally hear and dispose of the matter. Item 23.
My signal is just coming, Lordship. Let me hear, sir.
It is already 3:30. The counsel for the appellant is still absent.
Because they have taken, earlier they were very absent.
Just coming,
He's busy another. In this court, but pass access to order. Then on last occasion, they have taken time.
Just coming.
Last,
Just coming.
they have taken time. Now the matter is there. So my lord is very, matter is very, because if she is coming, I may be allowed to start only with the other facts of the case.
No. Who will start? Who has the right to begin?
They have right to start first. The
Then-
facts of the case, to make the court aware about facts of the case.
No.
Make the court aware about facts of the case, otherwise. Right. But these last 3 years, they are taking time for the case. Whenever the case is on this or that, they take time. Because
Today is
they
ready,
are
Lordship.
merit the case. If they go merit the
Today
case,
she is
no
ready,
merit.
Lordship. Just coming.
So they are always taking time in the case.
Now I will sit here waiting to come the counsel for the appellant.
If the court, So, you have two options, either I can appraise the court about the facts of the matter.
Sorry.
So otherwise, case may be dismissed. Then that case.
Sorry. You take it that. Yes, can. I have some other work also.
Your worship to pass some order.
Mister, your name please?
And Bora Lordship.
Learned counsel. Appearing for the appellant. Submits that conducting counsel. Who?
MD Shodri Lordship.
MD Soduri will appear in this matter, but after waiting for some time, the council failed to turn up, for which the matter stands adjourned to be listed. After 2 weeks,
To my lord.
Mr.
My lord,
Sharma,
kindly
learned
my lord,
counsel,
one date may conclude. 20th of the
for
February,
the respondent present.
20th January, my lord,
Okay,
20th January.
okay.